counsel Mr. A.M. Gora that item 43, 44, 45 bail hearing matters, my lord, BH, my lord, may be taken up after the motion, my lord. Here's some urgent work. That is obliged, my lord.
Mr. Borua is fine, I mean, can we take a note?
No, I have some personal problem today.
Hmm?
So, 2 minutes. So,
Yes.
item number 56.
56,
Bail hearing. It may be taken at 2 p.m. Some-
2 PM,
2
2 PM it will be, I mean, I can't say,
57. Tag matter. 56.
Both are from the same Azhar Miller.
at 2 PM we cannot guarantee, there are other matters also. We'll see, I mean, see how it goes.
Then at 1 minute, if you will.
No, that, I mean, that upgrading will be little bit difficult.
There is a time say at 2 p.m. So I have to, Azhar Miller problem.
Now, let's see, I mean, other matters are also there, I mean, if time permits, definitely we'll take it, it will be taken up. You are here today, no?
I am here, but some,
I mean, it will be taken up.
my lord.
Item number 13, admission matter also.
13,
13.
Yes.
TCR has been called for, TCR has come with this, received, I have taken the file
Ah.
also. Reminder will be issued for TCR also. I have informed the other side also.
Item number 13. The item number 13, you write, the learned counsel and Hassan, Mr. Learned Counsel. The learned counsel appearing for the petitioner submits that TCR in the instant case is yet to be received.
13, no?
Registry to send a reminder for calling the TCR in the instant matter. Let the matter be fixed in the first week of March.
First week of March. Okay.
Lordship, in item 34, I have filed an additional affidavit. Lordship, kindly be pleased to call for that.
What is this additional affidavit?
Got on record the service report of the bailable warrant of arrest issued against. It was not properly executed.
Okay,
34.
May I please, your lordship? My lord, as per order dated 16/10/2025 and 9/2/2026, my lord, in item number, my lord, 25, my lord, the matter was supposed to be listed before appropriate bench. Appropriate bench is my Honorable Justice M.K. Kolita, my lord, because some other matters were disposed of, my lord. So, as per order dated 9/2/2026, it may be,
which matter?
my lord, item 25.
25, what has happened?
My lord, some other matters have been disposed of by the Honorable Court, my
Okay,
lord, M.K. Kolita, my lord.
so
So,
it should go to the appropriate bench.
yes, ma'am.
Mr. S.S. Siddharth, the learned counsel appearing for the accused applicant submits that similar matters have already been disposed of
Yes, ma'am.
by a coordinate bench of this court. Accordingly, he submits that the matter, this application should be also placed before the appropriate bench. Let the matter be fixed before the appropriate bench.
In the meantime, interim may be continued.
Let it be before the appropriate bench.
Obliged.
May I please, your lordship? Lordship, beg to mention item number 47 of supplementary list, lordship.
47,
47.
yes.
Lordship, matter may kindly be adjourned for the day, lordship.
On the prayer of learned counsel appearing for the
Interim is
supplicant,
there,
that matter is adjourned and the same will be listed on 6th of March.
Interim may continue, lordship.
Interim orders of past earlier shall continue with the next date of listing. CD yet to be received. That's all.
Ma'am,
6th of March.
Like
May I please, your lordship? Lordship, I beg to mention item number 50, my lord. This
Hmm.
case, CD is not received for us, my lord.
CD not received, let the matter be
Petition is
fixed.
in interim, my lord.
CD not received, let the matter be fixed on 10th of March. Interim orders of past earlier shall continue with the next date of listing,
Petition, my lord, 12 of March.
12th of March.
My please, your lordship. Lordship, I'd like to mention item number 31, your lordship.
31, yes.
Lordship, I have to submit an additional affidavit. your
Why
lordship.
additional affidavit? Why?
I have subsequently, I have collected some additional documents your lord, and also submitted
is
a
for-
writ petition, your lordship.
Huh?
Also submitted a writ petition on 10th February, your lordship. That also not listed, your lordship. Any
Yes.
date next week, your lordship.
So on the prayer of the learned counsel, the matter is adjourned and the same will be listed in the first week of March.
Mr. May kindly on 26th or 27th.
No, first week of March.
May I
Obliged.
please, your lordship?
Lordship, I beg to mention item number 46 for adjournment.
43,
46, Lordship.
on the prayer of the learned counsel appearing for the accused applicant, the matter is adjourned and the same will be listed in the first week of March.
Lordship, petitioner is on interim, Lordship.
Interim order so passed earlier shall continue till the next date of listing.
Obliged, Lordship.
May I please, Your Worship?
It may be fixed on the CD not. 12 of March.
12th of March, yes.
May I please, Your Worship? I beg to mention item number 48, my lord.
Hmm.
FSL report not
Hmm?
received, my lord. 48, 48, my lord.
What happened? Okay. On the prayer of the learned counsel appearing with the accused applicant, the matter is adjourned and the same will be listed on 13th March.
There is an interim, my lord.
Interim order so passed earlier shall continue till the next day of listing.
Obliged, sir.
Please, your lordship. Lordship, I beg to mention item number 26, case diary is not available and
CD not received, let the matter be listed.
interim may be continued.
Listed on 11 March. Interim order so passed earlier shall continue till the next date.
What's your place, lordship?
Lordship, a little pair, Lordship, for item number 46, kindly be, let it be on 13th of March, Lordship. 12,
Okay, 46, make it 13.
obliged, Lordship.
May I please, your lordship? I would like to mention item number 52. Praying for adjournment for day, lordship. Engaged council is having some difficulties.
Okay, on the prayer of the learned counsel, the matter is adjourned. And the same is to be listed on 13th of March.
Lordship, interim order is
Interim order so passed earlier shall continue till the next week.
obliged.
I like to mention item number 19, my lord.
Hmm?
I have checked, my lord. TCR has not been received, my lord.
Okay. Item number 13, you write.
19, my lord.
TC 19.
19, my lord.
TCR not received, let the matter be
Reminder.
listed on 16th of March.
My lord.
16th of interim is there.
No, my lord, it is in jail, my lord. Can it be
Si-
little bit earlier, my lord?
Then make it on 11th of March.
My lord. Obliged, my lord.
Item number 1, item number 2, and item number 6 arising out of the same affair. Your lordship may call for the CD and matter may be fixed on Monday, lordship, because another case is coming on Monday. In that case,
1, 2,
CD has already been called.
1, 2, and 6.
1, 2, and 6, yes. Another bail application is coming on Monday. In that case, CD has called.
Heard Mr. So-and-so.
Okay. On Monday.
The learned counsel appearing for the accused of so-and-so. Learned counsel appearing for the accused applicant also heard Mr. K. Parasar, learned APP for the
23.
state. This is an application under, just write it as. The case relates to unlawful confinement and demand of money. Full stop. Let the CDV call for. We submitted that another bail application. What is the bail number?
BA 390 2026,
So and so is being listed on Monday.
Monday.
Monday, that is on
23.
23rd. Since the matter relates to the same FIR,
Same.
it is prayed that the matter to be listed on Monday. Prayer is allowed, let the matter be listed on 16th along with the aforesaid bail application. Same order will go in other case. Same, no?
Same. 1, 2, and 6. Item 3. Yes.
1, 2, and 6, same order.
May it please your lordship, regular bail application. Out of the same affair and same forwarding, lordship has already considered the bail application of the co-accused I have annexed the Lordship's order at page 18, starts from page 18. May I pray that similar order may be passed? Same situation, same facts and circumstances.
No, they are named in the FIR or not?
No, Lordship. No, Lordship. Lordship's order has been detailed. Observation is there at page 19, operative portion.
In that case, police recovered three pet dogs from the.
The other,
was-
those who have,
Yes. Regarding this?
Is this the case of the black magic?
No,
Lordship.
dogs were found.
Okay, dogs.
Street dogs.
Page 19, Lordships.
They were trafficking dogs to Nagaland, madam.
You were there in how many days? There for how many days?
From 5 to Lordship.
One person only.
No, Lordship, here 3%.
You-
Total 7%, Lordship in,
No, here, how many persons are there?
3% here, Lordship.
But you have written only one person's name.
Another is absolutely. Page two, 3% total.
3%, Lordship.
The page 2 is, I have seen it, but why this on the cost title only one person's name? The, it is written as petitioner only. Heard MST Som, the learned counsel, appearing to the accused applicants, also heard Mr. K.K. Paraswal and APB for the state. This is an application you write. An FIR was, same FIR.
Same.
An FIR was lodged on 9/12/2025. 9/12/2025 by one Priyam Jyoti Fukon, an animal lover, stating that there had been a large-scale disappearance of stray dogs from various localities of North Lakhimpur town. Being an animal lover, he made inquiries into the matter and found that several dogs had gone missing in recent weeks. In view of the aforesaid, he filed a FIR for the North Lakhimpur police station regarding the missing dogs. Next part I read, upon receipt of the FIR, police registered Lakhimpur PS case number 435/2025 under the aforementioned sections. During the investigation, the police recovered how many dogs?
3,
3 only.
yes.
The police recovered 3 stray dogs from the possession of the accused applicants. The police forwarded the accused applicants to the learned CJM. Same date,
Yes, Lordship.
CJM North Lakhimpur, some on 6/2/2026, and since then the accused applicants have been in judicial custody. The learned counsel accused applicants submits that the accused applicants have no way connected to the aforesaid allegations of missing dogs. Rather, they kept the dogs out of affection and were not involved in selling or consuming them. 6, having heard the submission made by the learned counsel for the accused applicants, and also taking into account the matters brought before this court is of the view that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicants will be released on bail forthwith upon furnishing a bail bond of ₹20,000 with a surety. 20,000 each with a surety of like amount to the satisfaction of the learned chief judicial magistrate, command of Lakhimpur, Assam, subject to the following conditions. Take it from here. It is there in the order. There is an order. In view of the aforesaid direction, the instant bail application is accordingly disposed of as allowed.
I'm deeply aware.
So notice has to go in this.
Yes, Lord.
Notice and
But
here.
Heard M.S.M. Devi, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Paraswal, learned APP for the state. This is an application under so and so. The case, An FIR was lodged on 7/8/2025 by the informant before the Nagaur police station, alleging that the accused applicant has been harassing his minor child and harassing his minor child sexually, and also threatening her with sending certain obscene messages and computer generated obscene photographs of her. Full stop. It was alleged that after with the aforesaid blackmailing of the minor girl, the accused applicant has raped her. Full stop. On receipt of the FIR, the police received the Nagaur PS case number 625/2025 under the aforementioned section. Let notice be issued on respondent number 2 through the registry as per the prevailing notification of Gauhati High Court. Notice to respondent number 1 is dispensed with as the learned APP enters his appearance in the matter. Call for the case diary. Let the matter be fixed on
My lord, on 9th.
9th of March.
Lordship, in this case, if the petitioner has been suffering from a gallbladder inside the jail, Lordship.
But
they
it's a
will-
POXO matter, madam. We'll have to issue notice to respondent
Yes,
number 2.
yes,
That's a mandate.
Uh,
So,
but,
without
a
serving a
direction may be given to the jail authority to give proper treatment because surgery is required, immediate surgery is required, Lordship. I have annexed all the documents at page 45, annexure 8.
in the learned counsel appearing for the accused applicant submits that the accused applicant is suffering from what?
Gallbladder,
Suffering
you-
from suffering from
kidney stone, Lordship.
suffering from some renal problems. Therefore, renal problems,
calculus.
therefore, she prays that the proper treatment should be given inside the jail to the accused.
Medical report may be called for
Accused applicant.
from the jail.
Accused applicant.
I have annexed
In
all
view
the
of the, in
documents.
view of the aforesaid submission, it is directed that a medical report to be submitted before this court by the jail superintendent through you.
We will.
Jail superintendent through the office of the public prosecutor. Full stop. In the meantime, if there is some medical treatment is required, the same should be provided to the accused applicant by the jail authorities.
Oblige.
5.
Lordship, there is a 482 application. Charges which has been laid are under sections 20B, 2B, 25 and 29 of the NDPS.
It's a commercial quantity. Right?
No.
No, not commercial.
Below
but
commercials,
below
7
How much quantity?
commercial quantity is 20 kgs.
No, how much you have
7.1 kg has been recovered. from the
7.1.
Yes.
Okay, we'll call for the CD. We'll call for the CD. Heard, Mr.
As
Succeeded. Okay,
TCR.
heard, Mr. S. Doctor.
as the
As Doctor, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Paraswal and APP for the state. It is an application under so and so. The case relates to recovery of 7,188 grams of suspected cannabis from the possession of the vehicle, from the vehicle which was, you were driving or?
No, I was not driving. I was named by the driver.
Okay, from a vehicle, thereafter the driver of the vehicle implicated the accused applicant. Call for the registry to call for the TCR in the instant case from the court of which court?
Special court, Sri Bhumi. Special
From-
judge Sri
From the court of special judge Sri Bhumi. Let the matter be listed on
11th of March.
11th of March.
Oblige.
7.
Right, legal market. Dear my lord, at the outset, I want to say, my lord, that I've been informed that 103 has been added in this case, my lord.
Hmm?
103 murder section has been added, my lord.
Okay, we'll call for the, CD.
CCD, my lord, CD at this stage, my lord.
Sorry?
At this stage, lordship may call for the CD
Yes,
because
sorry.
mother has been added, mother.
Mhm.
And that if it is added, I will file an additional affidavit. Actually, my lord, what happened, my lord, the petitioner before your lordship is the principal of a school. And cycle was stolen from that school, my lord.
Mhm.
And my lord, some parents, my lord, my lord, went to the house of the mother, thief, my lord, and they beaten the thief. But as he is the principal of the school, my lord, he was summoned twice, my lord. He went to the police station. I have categorically stated, my lord, that they have went.
But 302, that
103
the,
now.
103 has been added,
Yes, yeah.
added against him also.
My lord, no, against, the case is against no one, my lord.
The case is.
But the petitioner was summoned, my lord, to the police station.
Hmm.
But accordingly, he went, my lord. I have categorically.
But this is AB, eh?
Every
AB.
month, categorically, he stated, my lord, he went and his statement was recorded. But my lord, now recently 103 has been added, my lord. So,
Okay, we'll see. So I
not
guess.
in that case, my lord.
We'll see.
If
Heard
that-
Mr. S.M.
I-
Abdullah P., the learning council, appearing to the accused applicant, also Mr. K.K. Parasar, learned APP for the state. This is an application number so and so. The case relates to an FIR lodged on 26/1, 26/1/2026 regarding regarding grievous bodily injury and subsequent death, no, subsequent death
But
of
that
the.
I have informed, my lord, but
s-
here regarding death, nothing has been
Okay.
written in the FIR.
Grievous bodily injuries, injuries to the victim.
But the submission may be recorded, my lord, that I have submitted that succumb to his injuries, my lord. If that is so, my lord,
No, at this stage, why this submission? We'll call for this,
call for the case.
call for the case diary. Call for the case diary and let the matter be fixed on
But from Sirang, 9th.
9th of March.
My lord, there is a small typographical.
You bring on record if
But
there
if-
is subsequent.
there is typographical mistake also, my lord.
Where?
My lord, what's been, my lord, I'm very sorry about that, my lord. Here, my lord, in paragraph 3, I have written, my lord, that he is the principal of the school, head teacher of the school, my lord. That is correct, my lord. But in the first paragraph, there is a typographical mistake, my lord. So that
First paragraph where?
first paragraph, my lord, in the second page, my lord, page number 3.
What is that?
My lord,
A
he's a
businessman.
businessman, my lord. It should be the headmaster of the school, my lord. But in paragraph number.
Okay, we'll record it later. No, don't call. We'll record it later. We'll record it that like there was a mistake in it.
Not
Okay, we'll do it. Okay.
oblige, your lord.
Me, please, my lord. This anticipatory bill application has been filed in connection to Duliajan PS 196 of 25 and was registered under section 108 BNS. And the copy of FR is annexed in page number 13. And the type copy is annexed in page number 10. I may read the FR, my lord.
Well, she has been named in the affair, my lord. Nomi Bailum.
Yes.
We'll go through the CD. I heard Mr. Ms. So-and-so, the learning council,
my lord,
applicant, also heard.
If the protection.
No, I also heard, Mr. K.K. Parasar, learned AP for the state.
My lord.
This is an application under so-and-so. An FIR was lodged by one Ajay Barua of the Ajay Barua on 12/11/2025 about the death of his brother, alleging abetment of suicide against the accused applicant. Call for the CD, let the matter be fixed.
My
on.
lord, I'm newly joined in the job that. And
That is fine, we'll call for the CD
my
and
lord,
because.
if interim protection is provided, then at
No
least,
interim protection.
because the deceased was in love with me.
I mean.
And I am married woman, so I refused his proposal and that is what he did. So I'm nowhere in
She's
this.
a married woman.
The CD may be called for, but I also have some objectionable videos and documents to be produced before the IO. And till then, I may be protected. Because it's about my job and I'm newly appointed.
Appointed at where?
Appointed in Khetri.
Hmm?
And appointed my.
Appointed as what?
Appointment for operational manager in RBL FinServe. And my, this page number 24, there I have date of joining. 22nd,
Where
I
is
have
the,
already joined.
where is the FIR?
The FIR is in page number 10. Sorry, 13.
Type copy 10, madam, page 10.
Type copy in 10.
Okay, 1 second. What is to be, I mean, nothing.
Girl.
Analysis.
My lord, without having the degree of divorce, I cannot accept the marriage proposal, so I denied it. That is why he was.
You are married.
Yes, and I'm living separately since 2024.
क्या लिखा था FIR के बारे में क्या लिखा? No, FIR plus. Like you rewrite the paragraph. Huh? An FIR was lodged on when was the FIR filed?
FIR was filed on 23rd
Hmm?
of October.
12/11/2025.
11 suicide was committed on 23rd, sorry. And FIR was lodged on 13/11.
Hmm?
It was lodged on 13/11.
You don't write the date also. Hmm. 12th November. FIR was lodged on 12/11/2025 by one Ajoy Borua, alleging that his brother Nitumani Borua, aged about 29 years, committed suicide on 23 October 2025. Full stop. It was alleged that the reason for death of the reason for death of his brother is because of mental harassment by the accused applicant who constantly pressurized him to take this step. Full stop. It was alleged that certain certain objectionable messages were found on his phone, which fingers towards the accused applicant for mentally pressurizing him. It was also alleged that the brother of the informant was in a relationship with the girl for last 1 year and had been continuously falsely accusing him of having a relationship with other girls. It was alleged that 10 days before the suicide also, 10 days before the suicide, he tried to take his life by consuming sleeping pills. However, at that time he survived, and it was alleged that the girl, the accused applicant went to the hospital where he was treated, and there also he was being harassed by the accused applicant. Full stop. On receipt of the FIR, police filed Duliajan PS case number 196/2025 under section 108 BNS. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is a married lady and she was not in any relationship with the accused, with the victim person. She submits that the victim person was pursuing her to get into a relationship with her, but she used to refuse her as she was already married, and she was already married, though she was staying separately. She further submits that there is no evidence as such of abating the suicide of the victim person by the accused applicant in the instant case. She further submits that though the incident occurred on 23 10/2025, the FIR was lodged in a very delayed stage on 12/11/2025. Therefore, she submits that the whole implication as narrated in the FIR have been an afterthought, and therefore the accused applicant, who is a lady, should be granted bail at this pre-arrest bail at this stage. The learned counsel, next para, on the other hand, the learned APP opposes the bail at this stage without perusing the case diary. This court, after hearing the submission made by the counsel appearing for the respective parties and on perusal of the materials that have been brought on the records, is of the considered opinion that at this stage the accused applicant should be granted the privilege of free arrest bail, and accordingly it is directed that in the event of the arrest of the accused applicant by the investigating officer in connection with Duliajan PS case number Duliajan PS case number 196/2025, she shall be released on furnishing of a bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions: that the accused applicant shall appear before the IO within a period of 10 days of passing of this order. Next, that the accused applicant shall cooperate with the investigation and make herself available before the IO as and when required. Full stop. The accused applicant shall not try to influence any witnesses that may be involved in the instant case. In view of the aforesaid direction, the instant anticipated bail application is disposed of as allowed. But disposing it of.
Matter may be taken after some time also.
Why?
I am led by senior counsel Acer Sutris. I am led by senior counsel Acer Sutris. After some time also. Okay.
May please your lordship, conducting counsel is another court. Please kindly pass over the matter for the time being.
Why?
Conducting counsel is.
Who is conducting counsel?
M.I. Hussain, Mr. M.I. Hussain.
We cannot keep on passing over the matters at the motions. When the matter is called for motion. I'm giving it for the last time. I will not give it. If he doesn't want to come here, then let him be there. But Even the matter is in motion, then he should be here.
38, my lord, yesterday's matter, my lord, we have received a written, my lord. There is no case is pending, my lord.
No case is pending.
No case pending. From Howley, my lord. Howley PS, my lord, we have brought.
If no case is pending, then the why the police is visiting my place lots. I have given specific statement. An FIR is locked by the respondent number 2 lots. And that is not registered. FIR is not registered. But I am apprehending arrest. May kindly protect me.
This, legal indication record. WP message.
Then let him go. Let him go on.
No case pending.
But I mean, but thing is that he is apprehending and the police has been, that is his statement here on affidavit.
That is there, my lord, then, my lord, it may be in the order may be mentioned regarding the, my lord, any, my lord, petition or application filed by the informant, any name if he will provide, my lord. Otherwise, my lord, it will be blanket, my lord.
That is what I mean.
Any specific has to be given, my lord, any name, FIR filed by, who was the informant?
FIR I have given Rajiv Das.
Rajiv Das.
With where there is a litigation, title suit pending between the petitioner and the respondent number.
So the passing of the order in this kind of
Well,
things is
it's
difficult. Now,
difficult.
I mean,
will
he may be,
blanket order.
he may be sought in a different case. Then what
Yes.
happens?
No case pending, my lord, at this.
Okay, I'll pass an order, but let me think about this. I'll pass an order. What do you suggest?
No,
Only to the
but,
extent of no coercive action.
no coercive action or any.
Or that kind of order.
It has to be specific, any FIR filed by the petitioner in respect of the land dispute.
Lots.
If tomorrow other thing will come out, my lord,
So that is what the problem is.
Okay,
If,
that will
I
suffice.
mean, now he can do anything and
My-
he will be getting this privilege of this bail, it cannot happen.
That will suffice. My lord.
Hmm?
No coercive action was pertaining to the land dispute loss. Title suit. They have not been able to file a written statement lawsuit. That is why lawsuit, the court has fixed that date for ex parte hearing. Now they are pressurizing me to lawsuit for amicable settlement of the land dispute. That is the case, lawsuit.
amicable settlement, or it may not be pressurizing.
Along with the false document lawsuit that I have received an amount of rupees 2 lakh from Rajiv.
He may raise the issue before the court, civil court also, my lord, when title suit is pending, my lord. That did this
This is a criminal.
pressurizing, my lord, in a continuous case where space is.
Okay, we'll think it over. I mean,
my lord.
this, you're right. I mean, the order will be passed in the chamber. This matter. We'll think about this and how it is to be, I mean, how the order what order can be passed and how it can be passed. We'll think about this. Item number?
My lord, with all respect, my lord, take the disproportionate asset, my lord, husband and wife. And the husband, my lord, check period has not been provided, but it is from 2006, my lord. And income tax returns, my lord, we have already filed before the authority concerned, my lord. The FIR begins, my lord. One page is 21, my lord. If 23 is looked into, it is apparent, my lord.
Please?
Page 21, my lord. It begins, my lord, FIR. Then thereafter 23, my lord. I'll be very cryptic, my lord. My friend has said that apprehension is not there. 23, my lord. Second paragraph, my lord. Lordship may have found, my lord.
Yes.
During inquiry, the SO Sushil Kumar Tamili was examined and his statement was recorded. I went there many number of times. Page 23, my lord. Thereafter, kindly see the one paragraph just before the last one, my lord. it is evident that SO has acquired a large number of assets. However, the assets or investment in the name of dependents and his spouse, Dolly Horma Tamuli, are still to be evaluated. Most of the properties are in the name of my wife, who is a business lady, my lord.
Hmm.
Now, my lord, his turn, my lord. And notice has been served on me, my lord, that to my servant, my lord. And serving a notice to the, of course, my lord, servant, my lord. The section bar set, my lord, that it cannot be served on a servant, my lord. 66 nowadays BNSS, my lord. Those are immaterial, my lord. My friend has said apprehension may not be there, my lord. My lord, I'm ready to cooperate, my lord. I just sought time when the 35-3 notice came to me, my lord. No check period provided. And my lord, the first property from 2006, my lord, around 20 years.
Hmm?
Around 20 years, my lord. Check period should be when evaluated. my lord.
Check period is, I mean,
Check
what
period
now?
not provided by the authority, my lord.
Check period is not given.
Not given. Page 21, my lord. The second paragraph, my lord. Third paragraph, my lord. Last line. Samuguri Circle, District, Assam, in the year 2006 and 2016. It began from 2006, my lord. So the check period would be from 2006, and inquiry has been going on since 7 years, and case has been registered in 2025. Rest is on him, my lord.
Yes.
My first submission before your lordship, my lord. What has happened in this case? Regular inquiry was initiated way back in 2022.
22.
22.
Hmm.
It appears from the
Preliminary inquiry was there.
regular inquiry, my lord.
I said regular inquiry only started, okay.
Not really. It
Hmm.
was kept pending, my lord.
Hmm?
That's why matter came up before it was taken up by CM Vigilance, my lord. For last 4 years, nothing has been done, my lord.
Last 4 years, nothing has
Nothing
been
has
done.
been
Yeah.
So it was again. Now we have issued a notice to him
Hmm.
that he may appear. No apprehension. Why will we arrest him, my lord?
You appear.
That may be
The
recorded,
notice, he has enclosed the notice also.
Yes, sir.
You have received notice, go and appear.
And 35-3,
No.
I cannot arrest him. If he appears, matter ends, my lord.
Yes, but that part may be recorded, my lord. Some fear, my lord. So many officials against me. in
At
that
paragraph
department.
4, he has stated that he is also not apprehending, my lord, because paragraph 4, your lordship, kindly see, he says that.
And if there is a statement of not apprehending, then you have apprehension gone. Para 4,
Page 4, page 6.
Apprehends arrest, my lord.
Page
Huh?
6, page 6.
page 6.
That apparent no non-bailable offense under section so and so.
This is my contention, my
No
lord.
non-bailable offense is made out, my lord. If non-knowledge is there, so where is the question of apprehension, my lord?
My lord, that is, my lord, my theory, my lord. My apprehension,
Pa-
I quoted
page-
in para 4, my lord.
Para 6.
Paragraph 4, my lord. Page 4, my lord. And thereafter, my lord, that regarding apprehension, my lord.
Apprehension, they say inter-department liability. Question of when I'm issuing a notice, he has to appear. If he doesn't appear, then question of apprehension will
Well,
come.
very much, my lord. Only that part may be, his submission may be recorded. I'll appear tomorrow, my lord.
Notice your lordship will find at page.
No, see, there is a notice issued to you.
Yes,
You were supposed to
I
appear.
sought time, my lord.
You sought time, now you need to appear.
Yeah, I'll appear tomorrow.
You appear, and like, where is the question of like arresting you or like giving any
Well,
kind of
normally-
relief by this court?
Normally, my lord, nowadays, my
No,
lord, disproportionate asset, earlier
If,
nobody was
if that is the case, then I mean, if on every notice that has been issued to any citizen of India, then he will approach this court for a pre-arrest
Yes,
bail.
yes, yes.
That cannot be granted,
Done.
just like that. So
Okay.
you'll have to show that, like, I mean, what is your, big apprehension?
My lord, can I just please?
Yes, please.
Earlier trend was, my lord, in a disproportionate asset case, my lord, nobody is normally arrested, my lord. Now, my lord, one recent case, what they have done, my lord, a lady, my lord, Nupur Bora, she was arrested, she was granted the privilege of bail, my lord. In the case where he accepted bribe, my lord, 7. Thereafter, my lord, in a disproportionate asset case, recent trend, my lord, she has been booked, my lord. She was called by a 35-3 notice, my lord, different spectrum, my lord.
Nupurbar case is different, my lord. In a house, more than lakhs of rupees was recovered.
My lord, I'm not never saying that. He's very correct, my lord. Only, my lord, one line, my lord, that PPA
Because subsection 3 very says, my lord. Your lordship goes to 35-3, my lord. Subsection. He says that of the BNSS,
Should I record your statement?
Yes.
Yes,
He-
yes,
he will not be
Yeah,
arrested.
yeah,
He's
admit that
saying
fact.
recorded, my lord. That
They-
we know, my lord.
Because 35(3) says is issuing a notice directly a person against whom
Yes, yes, yes.
reasonable complaint is made, credible, or actually he has committed conduct, he appear before him, so and so. Question of arrest doesn't arise. If he fails to appear, then question of
No, you have taken only a time, short
Time,
for
Yeah,
time.
their issuance itself, I'll not say, my lord, it is to my benefit. But to be honest, my lord, that may not be recorded, my lord. 35 notice, they cannot serve 10 years, my lord. But that's a different matter, my lord.
for
As
his
because-
benefit, we are serving it.
As because they have served, we are happy, my lord. Only his statement is to be read. Kindly, my. Yeah, yeah, thank you.
Then there is no, then there is, I mean, no order is required. He's stating that he will not be
No,
arrested.
only deadline, my lord. Something on record, my lord. Again, it will continue for 10 years. Again, some officer will come. Again, sub me a notice and put me behind bars. Man, this happens here, my lord. He also knows.
Don't know.
Normally,
How can
my
it
lord.
be?
Then only recording his statement I'll dispose of without
Yes,
any
yes,
order,
madam.
without any order from the court.
Yes, yes, my lord. Yes, my lord. Yes, my lord. Very much, very much. We'll be very happy, my lord.
But he will not be arrested till what, when?
The question of arrest doesn't arise if he cooperates, my lord. Because their
But that
language
will
very.
be added, my lord.
No arrest can be made without prior permission of specific, in the PNS is there.
But during the investigation, if some materials are found,
Then also you cannot arrest him, my lord.
Hmm?
He's
Materials
very-
are,
He's correct, my lord. Let it be recorded.
because it's a question of documentary evidence
Yes,
and he already retired. So it's a question of assessment.
Then I'll record only that on the assurance of the
yes, yes, yes.
special PP,
Yes.
Yes,
on the assurance of the special
my lord,
PP.
my lord.
Unnecessarily dragging the matter will not serve the purpose.
My lord,
You-
my lord, I'll appear tomorrow, my lord.
Let him appear, my lord. Let him cooperate. Matter may be expedited, my lord.
Heard
The
Mr.
law
B.K.
pending.
Mahajan, the learned counsel, appearing for the accused applicant, also heard Mr. P. Kotak, the learned special counsel, CM Vigilance. This is an application under so and so. That an FIR was lodged on 10/12/2025. A complaint was, the FIR was lodged on 10/12/2025. By one Jayanto Kumar Das, Inspector of Police, VNAC Assam to Assam Gauhati, VNAC Assam, alleging that a regular inquiry was initiated based on a complaint petition submitted by Atul Bora, MLA, Dispur, LAC before the Chief Secretary, Government of Assam on 18/3/2019 against a suspect officer Susil Kumar Tamuli, stating that he owned a huge number of properties with a request to institute a CBA inquiry into the matter. It was alleged that during the course of inquiry, it is evident that the aforesaid Sri Susil Kumar Tamuli had acquired a large number of assets. However, the assets and investments were in the name of his dependents and his spouse, Srimati Dolly Sharma. Full stop. The investigation is still going on in the instant case. On receipt of the FIR, the vigilance, the officer in charge of Vigilance Police Station registered a case bearing Vigilance Police Station case number 33/2025 under section 13 in bracket 1 small b in bracket small b stroke 13 stroke 2 13 bracket 2 and 12 of the Prevention of Corruption Act 1988 full stop. Where is that notice, 35 notice?
My lord, we have annexed, I'm pressing,
Page-
my lord.
It is
We have annexed the application, my lord.
page
that
three
occurs
forty,
at
my lord.
Hmm?
Page
Three-
340.
340.
340, my lord. Three 41 is our time seeking application, my lord. 340, my lord.
The learned counsel, Mr. B.K. Mahajan, the learned counsel appearing for the accused applicant
It begins at 340 and at 341.
submits that a notice under section 35.
340, my lord.
35(3) BNSS has been received, BNSS, which was issued by the inspector cum IO of the case to the accused applicant dated 10/2/2026 was received by him. When did you receive it?
I did not receive it, my lord. My house,
It's allowed.
domestic help, my lord, he received it. C, my lord. That occurs at page, my lord. 341, my lord.
Was received by a domestic help of the accused applicant. Full stop. On receipt of the aforesaid notice.
Yes. Time is agreed. And our
No,
application, my
one
lord,
sec-
three
one-
forty
one
one
sec-
A.
One second. By the aforesaid notice,
Medical.
the accused applicant was directed to
The
appear
medical.
at 10:30 a.m.
Get
on 13/12/2026 at the office of the Senior Superintendent of Police, Chief Minister's Vigilance Office, Rupnagar. On receipt of, on getting information about the notice,
I sought 15 days time, my lord. That occurs at 341 capital A, my lord. Page.
your wife has written it, right? First one.
My lord. Wife has short time, my lord. Husband was away, my lord, because of sickness.
It is submitted that on receipt of the, on receipt of the aforesaid notice, the wife of the accused applicant, namely Dolly Sarma Tamuli, wrote a letter on 13/2/2026 to the inspector of police cum IO, Vigilance Police Station, Guwahati, intimating that since her husband was not keeping well and was on leave, they require 15 days time for his appearance before the concerned superintendent, senior superintendent of police. Was there any reply to this?
No.
This full stop. In view of the aforesaid facts of receipt of notice and his non-appearance on the scheduled date on 13/2,
Fine.
13/2/2006, the accused applicant is apprehending arrest in the instant case, and therefore he has approached this court by filing this instant pre-arrest bail application. Mr. P. Kotoki, the learned special public prosecutor, CM Vigilance, has stated that the issuance of notice under section 35(3) is is, is a routine matter in this kind of cases. And therefore, there is no apprehension on the part of the accused applicant of his arrest at this stage. He further submits, he further assures that, that if the accused applicant appears before the concerned senior superintendent of police, CM Vigilance Cell, there is no question of his, there is no question of his arrest at this stage. Full stop. Since there is assurance given by the learned special public prosecutor, which is, you also agree with this?
Yes, yes.
Which
No,
is, which is,
That will be before the investigating officer, my
Huh?
lord. Appear before the not senior superintendent.
not, he was, in the notice, he was asked to be appeared before the senior superintendent.
Oblique or investigating officer. And continues to cooperate. my lord.
Notice was issued by
Hence,
the
you were directed to appear before, the
office of the superintendent.
officer superintendent officer. Okay, officer.
And
You can run IO or IO, IO. You can write investigating officer.
The notice was issued by the investigating officer.
Investigating officer. In the office of the senior, in the office of,
Must
yeah,
be there, yes.
in the office of the senior superintendent of police, you can write, huh? On such assurance, the learned counsel appearing for the accused applicant submits that he is willing to appear
My lord.
before the concerned IO on
Any day, my lord, within 3 days, man.
within
3 days.
within 3 days of passing of this order. In view of such assurance given by the learned special public prosecutor, which is agreeable to the learned counsel appearing for the accused applicant, this court finds it not necessary to pass any further order. Therefore, the instant application is disposed of on the assurance given by the special public prosecutor that on appearance of the accused applicant before the concerned IO within the time specified, he shall not be arrested by the investigating officer in connection with Vigilance Police Station case number 33
My lord, my lord,
stroke 2025.
my lord, my lord.
Will it do?
Yes, my
Yeah,
lord.
yeah,
No.
yeah.
He will cooperate, my lord.
And my lord, and thereafter, he'll continue to cooperate with the investigating agency, my lord. That line, if possible, may be added.
That can be added. It is further assured by the council, that counsel appearing for the accused applicant that he will fully cooperate with the investigation and make himself available before the investigating officer as and when
My lord, my lord,
required.
my lord.
In the aforesaid terms, the instant AB application is closed
Highly-
and disposed of.
Dispose of, my lord.
Closed and disposed of.
Highly ordered.
There is no issue?
No issue, my lord. Provided he appears, sir.
My lord.
I guess it's not a, one second, I guess it's not a blanket kind of an order
No, no,
No,
no,
not Bengal.
no, only as regards this case, my lord.
in connection with this. We have written.
Yes, my lord. Only one case has been registered against.
But subsequent incidents, subsequent materials,
Something also, it will concern with this case only, madam. It's a question of disproportion, already inquiry completed. It's a question of assessment, madam. Whether the,
Normally, they do not arrest, my lord. It's a
because
fact.
whether the
But
income
he
of.
is honest enough, my lord. And nowadays, what has happened, fear psychosis, my
No,
lord. My
no,
job
no.
will go, nobody submits honest.
He's already retired, my lord.
he's
The
already
biggest
retired.
part.
Retired.
He's
No, no, I
retired.
have not returned. I have filed an application for giving me voluntary retirement that has been kept pending, my lord.
You filed when? When did you file it?
That I do not know, my lord.
5 years back, 6 years back,
2-3
recently,
years back, my lord.
or after filing of the case, after filing of the
No,
complaint?
my lord, because my wife is pretty richer than me, my lord, in all, my lord, with all respect.
Okay.
11. Yes, please. My lord, in this case, my lord, the poor, my lord, the convicts, life convicts, my lord, before your lordship, who have, my lord, completed 20, more than 20 years, my lord, imprisonment. My lord, thereafter, the process was initiated for, my lord, release them.
We'll have to hear this matter, have to issue notice.
File. Your lordship kindly similar, the page, my lord, annexure 6.
Who is appearing for the other side? Mr. Borua, you are appearing? Hmm?
Right, my lord, we are appearing as legal aid counsel, my lord. Now.
You are appearing as legal aid counsel?
Legal aid counsel. They have completed, my lord, 14 years now on the ground of remission, my lord, as provided under section.
So we'll have to hear them out, other
Fine.
side.
Lordship
So we'll
may-
issue notice,
Fine.
heard Mr. B.K. Sen, the learned, the learned legal aid counsel, appearing for the petitioners. Appearing for the petitioners. This is a, you write, the instant application, the instant petition under Article 226 of the Constitution of India has been filed by the petitioners with the petitioners submitting that they have already spent more than 20 years. 20 years in judicial custody. Where is the judgment
Hello,
of
annexure
conviction
1, annexure 1, page 30.
in terms of
In connection with session case number 133 of 2007, my lord.
in terms of the judgment and order? Where is the operative part?
My lord, operative part.
Your sentence? In
Yes.
terms of the judgment, in terms of the judgment and order dated 27/1/1 2010, whereby
Case 29.
the accused applicants were sentenced to undergo rigorous imprisonment for life each for offense punishable under section 302/149 IPC, and to pay a fine of rupees 1,000 each, in default of fine RI for 60 days each. They were also sentenced RI for 1 year each for their offense punishable under section 148 IPC. It was directed that the sentences shall run concurrently. The learned legal aid counsel submits that since they have already spent more than 20 years in terms of the aforesaid order passed by, that order passed by learned sessions, as you write, huh? You write this case number and the quote also. I'll just give it to you. Where is the order?
My lord, page, annexure 3, my lord, page 39. operative part, your lordship will find here.
Uh-huh.
Page
You
46.
write, conviction, judgment order dated, you write judgment and order dated. Dated so and so, passed by the court of, but passed by the learned court of additional session judge, FTC at Biswanath in sessions case number 133/2007. Okay. He submits that because since they have already spent 20 year, more than 20 years in jail, they should be really, you're praying for the release, right?
My lord.
Pray for release of the release of the petitioners. Full stop. Let the notice be issued. Let the notice be issued. There is no government advocate here now. Mr. Borua? You can serve a copy, probably. I mean, formal notice may not be required if you could.
I'll serve, ma'am.
Huh?
Within 2 days. I have served, my lord, but today they have not.
He's a
taken
legal
time.
aid counsel.
Yes. I'll serve extra copy. ma'am.
Let the notice be issued to respondent number 1, 2, 3, returnable in 4 weeks. It is, though it is submitted by the learned counsel, learned legal aid counsel, that copy of the petition has already been served on the government counsel, full stop. However, none has appeared when the matter was called for. In view of the aforesaid, it is directed that extra copies of the instant extra copy of the instant petition shall be served upon the government counsel appearing for respondent number 1, 2, and 3 during the course of the day. If I let today, give it to them today only, during the course of the day. Let the matter be fixed after 4 weeks.
Lordship may fix a date when.
No, I mean, it will be difficult. Let the matter be fixed after 3 weeks. After 3
Obliged.
weeks.
May it please your lordship,
Hmm.
this is a matter relating to grant of interim maintenance by the learned trial court, and it was affirmed by the revisional court also. Now, what has happened, there is a mandate under the provisions of CRPC
Hmm.
that assets and liability statement are to be furnished by both the parties. So lordship is aware of the judgment of 2021 2 SCC, wherein it is said at paragraph 65, the party claiming maintenance,
Which case, Neha?
Neha.
Hmm.
Your lordship is aware of that particular fact.
Hmm.
Now, what has happened, in this case, the wife has not filed the assets and liability statement.
Hmm.
And it has been also observed in the trial court's order. Your lordship will come to page 43.
So we'll issue notice at this stage.
The lordship can dispose of the matter also.
But
The
no,
directive-
I mean, other side is not there. I mean, we'll have to give a notice at least. Heard Mr. H. Chaudhary, the learned counsel, appearing for the petitioner. Petitioner. This is an application under section 528, read with section 442 of PNSS 2023. So you are basically assailing this order, right?
Exactly.
Assailing-
Only the trial court's order, we move the revisional court also.
Assailing the order dated, or assailing the judgment in order dated 11/9/2025, passed by the learned additional session judge in bracket FTC 1 Margarita in criminal revision petition number 202 in bracket 1/2025 bracket complete, upholding the order dated 27/2/2025, passed by the learned JMFC Margarita in miss case number 28/2022. Full stop. Issue notice to the respondent number 1 by way of speed post with AD. Full stop. uh, the steps for notice to be taken by the, learned counsel for the petitioner within a period of 2 days. Let the matter be fixed after 3 weeks.
The next date is fixed on 25th. The court would be insisting on
25th of,
25th of this month, February.
that won't be possible, Mr. Chaudhary.
So pending disposal.
He'll,
of the
he'll,
matter-
he'll have to intimate that this is there.
Pending disposal of the matter, at least the further proceeding that may be stayed.
Okay.
Stay of the operation of the interim judgment and order in 11/9.
It is directed that pending disposal of the instant petition, the operation of judgment and order dated 11/9/2025 is stayed
Oblige you.
till further orders.
Lordship, fixing up any date, it will be convenient.
After 3 weeks, how will you do that? After 3 weeks, it will come. Your judgment is stayed, huh? Don't worry.
Oblige.
I say after 3 weeks. Huh?
He has paid, my lord. The lordship will find FIR at page 9. Widow, my lord, they complain about the rate. Page 9. Against it 27 years. You also kindly note the address, matter both the informant and accused matter of 6 kilometers away, my lord. Informant address is your lordship minds. Village Gopal Nagar. And this is village Ali Nagar. We have stated it about 6 kilometers away. And next page you'll also kindly see, though it is dated 10/1/26, but it was filed actually on 12/1/26. You'll also will find page 26 format.
What are the other grounds, Mr. Chaudhary?
Yeah, other counts, my lord, I take to your lordships to pay.
See, first thing is that a 5 mile is not a distance, that's not a problem.
Yeah.
And filing,
Yes.
10/1,
The problem is she was set up by
10/12/1 is also fine.
She was-
Any other grounds?
He was set up by someone, my lord, with whom I am having the titles of page 30.
Page
Page 13,
1, 3.
yes. Your lordship, plaintiff one Rafiquddin. Plaintiff is one Rafiquddin.
Yes.
And present petitioner is Muhammad Anwar Hussain, number 3, my lord, defendant. Your lordship got it, my lord. Now this Rafiquddin's son, and Rafiquddin is an old person, my aged person, my lord, his son-in-law, one Farooq Ahmad, we have stated on the oath, my lord, in the paragraph. He is the person behind he set up this girl, my lord. This lady, not a girl, my lord. And your lordship will find page 21. Page 21. Court's order, my lord, civil court's order.
Page 21.
Page 21.
Hmm.
Yes, second paragraph, but this is a revenue appeal matter filed by appellant number 1, so and so, and number 3, my Anwar Hussain was present petitioner. Present petitioner, so and so, for cancellation of mutation in respect of Rafiquddin.
But how do you connect this guy?
My connection because he is my paternal uncle, my Rafiquddin.
Who is paternal uncle?
Rafiquddin.
Rafiquddin is your paternal uncle.
Paternal uncle, with
But
whom I am having some land dispute. My
land dispute.
This
But how
title-
this girl is connected to?
Connected because he was set
Okay.
up by that here, my lord, we have stated your.
But I mean, is there any, I mean, material to show that like, that she was working with him, she's known to her?
Materials I cannot show, but
then-
statement I have given, your lordship will find as per instruction of that here, my lord, your lordship kindly have a look to paragraph 4, my lord. Just my lord, paragraph 4. Even the superintendent of police, only he knows it, but ultimately he got transferred and subsequently these things happen. And we also filed a FIR, though it was not registered, my lord. Paragraph 4, page 4.
But Mr. Chaudhary, I mean, how you can say that like the girl has been set up? I mean, is there any connection with the girl and Rafiquddin? Is there any material to show
Yes,
that
only
Rafikuddin
thing
and,
I
and the
know-
girl is, the girl are pally with each other? And I mean, nothing has been, nothing is there.
But what we said, my lord. you
Now,
have
some
said
case,
that-
I mean, there may be, Mr. Chaudhary, there may be so many cases pending, but how will you connect that person with this?
Other cases not my lord, because you already.
I mean, I understand, but there may be a pending case, but that doesn't mean that like that girl will be, I mean, there has to be some material, Mr. Chaudhary. I mean, at least-
Cases, my lord, actually a person of Fitra having grandson, etc., my lord, 6 kilometers away, that is also, my lord, your lordship is to say that part also, my lord, probability of the case. It is true, my lord, victim, whatever she say, but she is not a minor, my lord, widow.
She is not a minor widow, but there is an allegation of raping her.
No.
I mean, and there is, Mrs. Chaudhary, there is no, I mean, material which can really link this
This is
lady
the
with,
matter only
this lady with Rafikuddin.
With my paternal uncle, I am having done this route, she is having a relation with them, that is the link, my lord, this is the link.
Difficult, Mr. Chaudhary, in this case.
Your lordship, see, my lord, what comes in the city, my lord, in time, my.
Interim, it will be difficult. I'll call for the city. I'll call for the city. Heard Mr. H.R. Chaudhary, the learned senior counsel, appearing for the accused applicant, assisted by Hussain, the learned counsel. Mr. K.K. Podasa, learned APP for the state. This is an application given. The allegation against the accused applicant is that on 10/1/2026, about 1 o'clock at night, the accused applicant accused applicant entering her house, raped her. Call for the CD, let the matter fix on
Second.
second.
Medical.
Medical report will come.
Old lady, I mean,
But even the one, she widow, my lord.
widow.
Was 27 years old, not old, my lord, in that sense.
But I mean,
It will come, my lord.
yes, that is not a proper word. Anyways, call for the CD along with the medical report.
As it be.
Can it be, my lord, your lordship, can it some idea, if possible?
No, no.
subject to this?
Second is, I don't think that before that it will be possible.
Next week-
Second is the next
Next week,
case.
several cases listed because of the second next month.
Obliged to.
Then item 10.
Please, I beg apology, my lord, when it was called for, I was on lag, my lord. I beg apology.
Yeah, when a Mosul is there, it should be there, you should be here.
My lord, but I was in lag in another motion matter. So, my lord, FIR is the page number 12, my lord.
Now we'll call for the CD in this
My
matter.
lord,
Heard,
in
Mr.
this segment, I pay for interim protection.
No interpreter. I heard,
I have
Mr.
the receipt, my lord, receipt.
No, maybe there. MAI Hussain, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. Recent application under so and so. The case relates to recovery of 45 numbers of cattle in 4 vehicles from the possession. You are whom? You are driver,
No, I am
You are
the
the
owner of the
owner.
vehicle,
owner of the vehicle.
as well as
Okay,
9 numbers of cattle.
From 4 vehicles. And the accused applicant is the
Owner of one vehicle,
owner of one
one
vehicle.
vehicle and 9 cattle, man.
One vehicle and 9 kettles. Kettles are still there.
Yes, my lord.
I mean, in custody.
Yes, my lord. I
Okay.
want to appear to show
But
the,
Jimma hasn't been given to you.
no, no, only the
Vehicle,
vehicle has been
Jimma has been given.
given, but I could not.
Okay, we'll see the CD. We'll give you a short date. Call for the CD.
It's a demo, my lord.
Let the matter be fixed in the
Fifth.
on 6th,
Six.
6th of March.
Only on this.
43 to 45.
Forty-five may be taken up. Petition number 410, my lord.
Hmm.
Lordship, kindly, the 4 person, as I have already read, my lord,
Hmm?
they were apprehended, my lord, 4 person in a car, and the owner of the car,
Where is the affair?
FIR
Yes.
lordship will find at page 82.
82.
type copy, my lord.
Yes.
With reference to so-and-so, I have honor to report that on 28/1/26, at about 5 PM, information was received from the so-and-so office to the effect that the large quantity of gas suspected to be intended for use in terrorism, intended, my lord, was being transported in a vehicle bearing number so-and-so, Gauhati towards Mehala. Acting out the information, police team Jurabat outpost intercepted the vehicle on so-and-so, 6 mile. Upon interception, vehicle found proceeding towards Meghalaya, and following persons, including a driver, was apprehended. During the checking of the vehicle, case and the articles were recovered. Total case 70,88,000. Then this is the rest are checks, my lord. All my lord, lordship will find 8 lakhs, 5 lakhs, 5 lakhs, 5 lakhs.
Total amounting to 36 lakhs,
Total amounting to, my lord, check
It is-
is 43,
43 lakhs.
43 lakhs.
So
In
altogether,
9 checks. 9 checks,
cash is 77.
70, 88,000.
Yeah,
Plus 43,
43 check, yes,
Checks.
yes.
that has been recovered.
And what else, what else?
That's all, nothing else.
Then original sale deed,
Yes, yes. Now lordship kindly see,
I think this is
they
only the
have also received
original
the
sale deed of,
sale deed also, they have page 40, one of the sale deed. Before that, lordship kindly see page 26, my lord.
page 26.
Yes,
We are looking at the FIR.
yes, of FIR, my lord. These are the sale, they have received, in the car itself.
The car itself, the money along with the sale deed.
Yes,
One
yes.
sale deed.
Yes, yes.
And
The sale deed is 40, page 40. There is one more sale deed, my lord,
okay,
page 25. I'll come to both the sale deed, my lord.
so one sale deed, there are two sale deeds or what?
Yes, there are
One
two sale-
original sale deed, measuring so-and-so, under so-and-so. Where is the other one?
page, my lord, I have annexed in page 25.
No, in the recovery.
Recovery, there's one, only one sale.
There is one only.
One.
Okay. Recovery one only, okay. Then
Then, my lord, page
Then
25.
during preliminary inquiry, interrogation, apprehension person revealed that a said money was already generated for sale proceeds of land to be transported for the purpose of delivered to the terrorist elements
Hmm.
through their agents with intention to create, okay.
So there is their allegation as
Hmm,
we had the agents,
discloses the-
terrorists. But
Okay,
initially case was different, but later on it was changed. The whole narration was later on changed by the investigating authority.
so three persons.
Yes.
three
When
per-
one driver,
4 persons,
yes,
Malikuddin is the driver.
yes.
Yes, then,
The Anwar Hussain, my lord,
hmm,
lordship now come to the page 25.
page 25, okay.
On the day of apprehension, my lord,
Hmm.
lordship will find everything.
So 27/1/2026.
That is the permission, my lord.
Pre-registration summary.
Yes.
The appointment date was,
Execution date 27 January.
so how come it is 11:47 PM? I mean, it's online because of that time has come over.
Yes, online,
Hmm?
online.
It is pre-registration formalities.
Yes, pre-registration formality.
So appointment was given on 29th at 1:30. Correct?
Correct.
Appointment was given at.
But the only 28, it was executed.
Hmm?
Plot was found that the 28 already.
So appointment was given at 1:30 PM, right?
Yes.
Then,
Then the on 28th, the registered sale deed been executed.
so he paid the challan on 28. Yes.
So 28,
Hmm. So
this is the
the-
registered sale deed.
Registered sale deeds at page 28.
Yes,
So 60 lakhs was the amount, consideration price.
yes,
As per this document.
yes.
So Anwar Hussain.
That is the
Again,
petitioner, my lord,
yes,
and the wife. Sorry,
Present
sold to my lord.
one Mustafa, or
This is they have sold to Nazmir Ahmed, Amina Islam and Mustafa Salim Ahmed. He is an SCS officer.
Anwar Hussain is the person arrested,
Yes.
and you entered with an agreement with one Mustafa and Nazmeen.
Then wife,
And Mustafa is an SCS officer.
SCS officer.
That's you are saying, right?
Yes.
And
So
his
they
wife.
have purchased the land
Hmm,
and they paid the money.
hmm.
This amount was cash amount. Madam.
And this is located where? Located at
In Panjabari.
Panjabari.
Yes.
The land is located at Panjabari.
Panjabari.
Okay. Hmm.
From here itself. Daranda, this is area.
Dwarantha.
Sorry, Daranda. So this is from
Hmm.
where
Hmm.
we got the money.
Hmm.
It's not an illegal money or that we have failed to explain. Though it is not necessary, it is the duty of the prosecution to show that the initially, but the carrying money is not an offense, my lord. Only thing is that whether we are the member of any terrorist group.
Hmm.
First, they have to establish that fact, my lord, that we must be a member and we have given it to some terrorists. There is some link to the terrorists. Only carrying is definitely would not connect. That is a on page 40.
The
the
carrying
safety-
for the purpose of facilitating.
Yes,
So that is the thing.
that is the thing. But
Hmm.
first of all, we must be a member.
No, you may not be a member also.
Then we have to give somebody who is a member.
Correct.
Only carrying,
Carrying for the purpose of giving somebody who is a member
yes.
of a terrorist
That has to be
organization.
established, that link has to be established.
Okay.
Page 40,
Acha, Anwar Hussain, what do you do?
businessman, man. I am the businessman.
You are a businessman.
Yes, I am the businessman, Mala.
Okay.
I have sold it for a specific purpose, Mala, and we are traveling.
So you wanted to
And
get
the one person,
you wanted to get your daughter admitted.
that was the initial, their case is the prosecution also that we want to admitted our daughter.
Hmm.
Because one person with us, my lord,
Hmm.
he belongs to an USTM university, was also apprehended along with us, my lord. Item 44.
Okay, 44 is different.
44, I am appearing. He is only, he is 43.
He is the person who is from USTM.
He is another person, my lord.
But he was not traveling in the same vehicle. Huh?
He was also.
He was also traveling in the same vehicle. I mean, you are appearing for how many? 3?
I am appearing for
Two.
3.
2 in this and like another one.
Yes,
3. And he's another guy, 4th.
4.
And he was also traveling with you.
Yes.
Correct. You are, how you are linked to USTM?
My son,
Hmm.
an employee.
Employee of USTM. Okay.
Came to Gauhati.
Hmm.
Anwar is the-
Hmm.
He's from Gauripur, I'm also from Gauripur. We together came to Gauhati on 27. On 28, my lord, Anwar has got some land selling business.
Hmm.
And I have some business. My daughter reading.
Anwar is not a resident of Guwahati. Yeah, Anwar. He is also from Gauripur.
He's from, my lord, my client is.
But he had a land in Dwarada. Huh?
He has a land in Dwara. He has purchased, that is the sale lead from whom he has purchased, that is the 40.
There's some Kolita or something.
Yes. Akshay Kalita.
Hmm?
In 2018, we have purchased from Akshay Kalita. That is the same land.
Same land.
Yes. Which we have sold.
Okay. Now, I mean, both of you came, then what happened?
So while proceeding,
Hmm. 1 second.
we want to meet, he wants to meet to go to the USTM. And there's a talk, there's an allegation that we wanted to deposit the money in USTM for the purpose of some seats, my lord. At the moment the name of the USTM came up, the whole narration been changed subsequently because paying the money to the USTM will not make an offense, my lord. So they have to make an offense
But he wanted to pay the money to USTM for what?
for the seats, my lord.
For the seat.
For the seats. That is their allegation, initial allegation, my lord. That is
No,
the-
but where is the initial indication?
that's not, their initial allegation.
And
they
that
have-
is not there.
there's
But
not
do
there.
you have any document to show
No.
that? So that your daughter is going to be getting, the daughter is,
Sir, initially, that was the charge. We are actually going for that to see whether it is possible or not. These are, some factors are there. But they knows it that the moment the USTM, that is the most important factor.
no,
here.
that is okay, that is fine, but in.
Otherwise, there is no case, my lord.
No, no,
Because
then
suppose I am carrying money
Hmm.
without any reasons, my lord. I got the money because I have a valid money, my lord. It's not that I have collected from the extortioning from the various sources. There's nothing, no sources, nothing. Here, absolutely, there is a source, and nobody pays nobody deals in the checks, my lord. If I am an
No,
extremist,
no, Mr. Bora, what court is trying to understand, you were carrying that money, it is understood that you have sold the
so
land.
then
But-
let us confine to that itself.
And
my
you,
lord.
you have prepared some checks also?
Yes,
And
the
checks are in the name of whom?
various person, my lord, because that is the checks were given to me.
Given to you?
Yes.
That's what.
So I am carrying all this so that I can deposit
Checks were given to him by whom?
by the actually this purchaser.
Against this purchaser,
Purchaser.
correct.
So it's not that I am and by virtue of checks
Mm.
will not going to pay it to the that an absurd proposition.
No, whether there, I mean, see, if you are, if you say that like I'm going to get my daughter admitted, then maybe a situation that you prepared some checks in the name of USTM, correct?
At that time, there's nothing offshore.
Nothing.
There's just some talk was going on, my lord, regarding the.
Mm.
But that was the initial. But that doesn't create any offense. That moment they have got to know that USTM is also some maybe involved, the whole narration has been changed later on, and they created an offense. Otherwise, they cannot put us behind the bar. So just to put us behind the bar, that the extremist angle was put in. Otherwise, where from the extremist angle is come? Who are we? There's nothing that we are the members of so-and-so. In the forwarding also, that during interrogation it is came up that we are the members of some activist group or something terrorist group, or we are involved, or we are planning to pay to the so-and-so terrorist group. Nothing of that sort. Simply on intention.
But in a lighter vein, I mean, with 77 lakhs rupees, why are you roaming around in Guwahati?
Just, it is from Gauhati to that day itself, my lord.
Hmm?
It's not that we are roaming around on that day itself, my lord. But 28 we got the money, to 28 evening we were arrested. It's not that we got the money in 1 month bank and we are carrying all over Assam, my lord. It's not that. On the 28 itself, everything is clear from the registered sale deed. And it is not an affidavit or
I mean, your people are intercepted where?
in the Jurabad.
Jurabad.
And here also money has been delivered. Everything has been Gauhati, just in the Jurabad. So it's not a case that we are roaming with the money.
You probably wanted to go to Shillong and spend some money. That's why you were intercepted in
Maybe.
Jurabad.
Some people, they have a habit of going Shillong to many occasions, like that. Anytime, suppose to spend.
So your case is basically, the facts are basically that.
Facts are basically that. Is there any angle to show it? It's any link. Any forwarding also next day, that there might be.
Where is there forwarding?
Page 90, my lord. 89 starts, my lord. Grounds of arrest, lordship will find. Page 90.
Page 90, yes.
From 3, my lord. 1, 2, they have recovered. We have satisfactory, we can fail to explain possession of transference as used money. Preliminary inquiry revealed that active involvement of raising and transporting funds for jihadi extremist element. There are acts of prima facie commission offense of so-and-so involving terror act and along with the section 2. There exists reasonable suspicion. They are linked. Only suspicion. There has to be some concrete material. And we are on 23 days in custody, my lord. And 5 days police custody also.
Including that.
Including that, my lord. And actually,
Yes, Mr. Borua.
I'll revert, my lord, if necessary, my lord.
Is there anything else, Mr. Borua, Mr. Bora, you want to submit?
No, no, not now, my lord. Let him say, my lord, what is there.
We'll just come back in
After
5 minutes.
five.
I'll
Yes, madam.
just come back in 5 minutes.
Offenses, my lord, 15, 16, 17, and 18.
15, 16?
17 and 18. Lordship, just have a cursory look at the provisions of the act.
Which act, which act?
This is the Unlawful Activities
Unlawful
Prevention Act
activities.
67.
Sanjay? Nice. No, no, no. Yes.
15, my lord. Whoever does any act with intent to threaten or likely to threaten unity, integrity, or security or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India or any foreign country. A, by using bombs, dynamite, other explosive substances, inflammable substances, firearms, other lethal, open, poisonous, noxious gases, other chemicals, or by other standards, whether biological, radioactive, nuclear, otherwise.
So this is not involved.
This is not. Next one, A1, death of or injury to any person. Doesn't come. Loss or damages to destruction of property. No, my lord.
This is not applicable because bombs, dynamite, all these things are not recovered.
Yes, yes.
Then,
Description of the supply of several essential life of the community of India, foreign country, no, my lord. Damages to the monetary stability of India by way of production of smuggling, circulation of high quality counterfeit of Indian paper currency, no, my lord. Coin or any other material. Damages, destruction of any property of India or in the foreign country used for intended to be used for defense in India, no, my lord. Overseas by means of criminal force. Or
BNC not applicable.
not applicable. Detains, kidnaps, abducts any person, threatens to kill, injury to such person, or does any act or in any compel to government of India, state of government of foreign country, not applicable. For the purpose of subsection, public functionary, not applicable. High. Now, 16 is the punishment, my lord. First part is the life. Second part may be 5 years or life.
So 17 maybe.
Now 17, my lord. Yes, 17 also very important. Whoever in India or a foreign country directly or indirectly raises, this is important. First of all, raises, provides fund or collect funds. First, we have to raise or collect funds, whether from a legitimate or illegitimate sources. Here we have a legitimate sources, my lord. From any person or persons, attempt to provide or raises or collect funds for any person or person, knowing that such funds are likely to be used in full, in part, or such person or persons by a terrorist organization or by a terrorist gang or by an individual terrorist to commit a terrorist act, notwithstanding whether such funds are actually used or not for commission of such act. So first of all, we have to raise money, collect money from any person. Raising funds shall include raising, collection of providing funds through production of or smuggling and circulation of high quality and counterfeit. Now,
C maybe, I mean,
yes, see, to a terrorist organization for purpose of not specifically covered by under 50. May not be, my lord, but first of all, it has to be, we must supply it to the terrorist gang. That supply is necessary, raising necessary for the purpose of, if there is a material that we have provided money to the terrorist gang or individual terrorist, where is that, madam? The money was seized from us itself.
yes.
Money was, there's no link that you are not a person. Somebody was not apprehended along with us. Who is a terrorist person, suppose? There's no allegation to that effect, my lord. Among the 4 persons, my lord, there no one is a terrorist. One is the driver, rest of the 3. One is the employee. And actually what happened, my lord,
18,
that's a conspiracy, man. So for the conspiracy also, there has to be one terrorist group or individual is necessary.
whoever conspires or attempts to commit
Yes.
or advocates, abets, advises, or incites directly or knowingly facilitates commission of a terrorist act. So terrorist act is defined.
Yes. Section 15.
So terrorist act is 15. Or any act preparatory to the commission of a terrorist act
Yes. 15.
shall be punishable with imprisonment.
So
So-
15 does not come.
So element of any material that you are involved, you are supporting or trying to support, the terrorist act has to be there.
Yes, first of all, terrorist, to whom we are supporting.
Yes, Mr. Borua, what?
And there's one, my lord, my daughter was, she was pursuing, my lord, medical
Hmm.
in West Bengal.
Hmm.
So she is not comfortable initially in there. She wants that to come back, actually. So there was a talk was going on,
Hmm.
and lordship, it's,
Gauri Devi Institute of Medical Sciences.
yes,
She is your daughter, Alisha Sabnam.
yes.
She is
That-
in which year? She is in which year?
First year, just.
First year.
Yes,
She wants to get transferred.
yes. There is some talk was going on. So that was the initial fact. And I've been told there's an agreement also to the USTM to that effect, that I'll invest, because this lordship knows in some cases, they shows it as an investment. While getting admission in the private colleges. So let my first of all, they have to establish, my lord, we had a link to terrorist gang or group or individual to whom we are knowingly going to facilitate. This
Yes, it's like.
on that day itself. Because one thing is clear, my lord, it is not a case that we have collected the money from the various sources from a long time, my lord. We have received the money voluntarily, legitimately, selling our land on that day itself. On that day we have apprehended. So terrorist gang, in case, my lord, yes, we have to collect it from the various sources from a long time. On that day we have received, and that day we have apprehended.
Correct. Got it. We got your facts. You have something more to add? Hmm. So your case is that you know this person, you are traveling with him, right? The both of you are from Gauripur.
Actually, I started from Gauripur.
Hmm.
I have a purpose, my lord.
Hmm?
I have a
Purpose,
purpose here
yes.
because my lord, my daughter read in downtown university
Hmm.
in business management, my lord, business administration. Now what happened, my lord? I am to submit some document in the bank, my lord. To collect that document, my lord, I came to Gauhati. When I coming to Gauhati, I have heard that Anwar also going to Gauhati.
Hmm.
So, my lord, I accompanied him in the car belong to Anwar because he is my friend. So, my lord, we 4 person, another person that he is employee of USTM, my lord. So, my lord, I came to Gauhati on 27. On 28, my lord, we live together night at the residence of some relative of Anwar. And thereafter, my lord, Anwar have some land selling business. So he went to the DC office. I went to downtown university, my lord. I collected the document of my daughter. And thereafter, what happened, my lord?
Those documents were recovered from the vehicle.
Not from the vehicle, my lord.
Hmm.
That was with me. That is not seized.
It was not seized.
Yes, my lord. So what happened, my lord? Thereafter, I was about to return to Gauripur. Then I called Mr. Anwar that whether your land selling business is complete or not. Then he said, yes, it is complete. I will also return to Gauripur. So we meet at Ganeshguri, my lord. So I again in the vehicle.
Why did you go to Zurabad?
No, my lord, I'm giving. So I said to Anwar that my son is an employee in Ustam, that USTM. So I want to meet him before leaving to Gauripur. Then the vehicle from Ganeshguri to USTM, my lord, proceeding. And thereafter, my lord, when proceeding to USTM, immediately that was get out by police. And I was in the vehicle. Even I do not know whether cash is available in the car. How much money he received, Anwar received from by selling land. I do not know. Thereafter, what happened, my lord? As I was in that car, my lord, I was also arrested. This is the position, my lord. I have annexed the document. That is studentship of my daughter, identity card of my son. I'm an ex-employee, my lord, ex-employee, that retired person, my lord.
How old are you?
PWT, my lord, 63 like this. My lord. So, my lord, what happened, my lord? I have given the pension paper also. So, under the circumstances, I was arrested.
No, that is your case.
That is my case, my lord. I am
Okay,
not.
okay, let us hear him now.
I am totally unaware of this amount, my lord.
Got it.
And regarding the amount, my lord,
You are not aware.
I'm not aware, and my friend, my lord, tried to explain how the money is.
Hmm.
And second thing is this, my lord. Lastly, I want to submit one thing, my lord. Supposing, my lord, there is something, not admitting, but I'm submitting to your lordship for consideration. Vehicle is seized, money is seized. We have been given in police custody. 23 days we are in custody. No, my lord, now thing is this, my lord, we are to face the trial. Nothing remains, my lord. The vehicle is seized, money is seized, everything is seized, my lord. So, my lord, my humble submission before your lordship, my client is not at all related with this case, my lord. And regarding this extremist connection, my learned friend elaborated, my lord. There is no, if the from CD, my lord, if it is established before
Correct,
the
correct.
lordship that there is a link, then matter will be.
We'll see what he says.
But we have received the case diary, my lord, and going to the case diary, my lord, the investigation is in a very nasal stage, my lord.
Hmm.
It requires further investigation, my lord. Although we have received the case diary, my lord. Now, my lord, on the day of incident, my lord, the 4 person, my lord, they were traveling together along with the case, my lord. So they were first intercepted, my lord. Then, my lord, money was recovered, and it was then my lord, they were interrogated, my lord. Where from they have got this money, my lord, they could not give any satisfactory reply, my lord. Then, my lord, they were taken to the police station, my lord. Then, on further interrogation, my lord, they have stated that they are going to funding for some fundamentalist to, my lord, unrest the state of Assam, my lord.
Hmm?
To unrest the state of Assam, my lord. Then, my lord, their statement also recorded, and during their statement, they have also stated, my lord, they, by way of, my lord, one sold it, my lord, they have got this money, my lord, and that money they are going to, my lord, yeah, hand it over to the, my lord, fundamentalists, my lord.
Any name they have given, whom to be given or something?
No, my lord, they are going to, my lord. They have not stated, but where they are going, my lord, they have stated, my lord.
Where?
To one place, my lord. That is, one, my lord, one place name is Killing, my lord, in the state of Meghalaya, my lord. Killing.
The
Now, my lord,
Killing is that
case
side only, that near, I mean, after USTM.
after West, my lord, maybe I do not know. My lord.
That side, yes.
Now, my lord, for the purpose of investigation, case has been registered under section 15, 16, 17, and 18, my lord. So during investigation, my lord, IO can add more section also, or IO may delete some section also if it is not applicable. Now, Lordship may kindly see whatever is section 17 says.
Any link with the terrorist organization, terrorist person in the material? Because it's already 23 days.
No, 23 days, my lord, they have stated so, my lord.
Hmm.
Because, my lord, whatever my learned friend has submitted, my lord, there are two sealed, my lord. But, my lord, from the case diary and my lord, the document submitted by my learned senior friend, my lord, it shows, my lord, one sealed was executed in the year 2018, my lord. Another one is the agreement for sale, my lord. Lordship may kindly come to, my lord, page number. Lordship may directly come to page number 33, my lord.
Hmm.
My lord, this is the agreement for land sale, my lord. Between the, my lord, Anwar Hussain, my lord, he is the owner of the land, my lord, which he has, my lord, LS2 purchased in the year 2018, my lord.
Mhm.
And, my lord, other one is the Mustafa, my lord. Now, Lordship may kindly see page number 34, my lord.
Hmm.
My lord, entire sale consideration is, my lord, is of 60 lakhs, my lord. And in, my lord, page number 34, para 2, my lord, that today the first party seller has received an amount of rupees 58 lakhs in cash and check as an advance for the scheduled lend from the second party purchaser, the receipt of which hereby admits and acknowledged by the first party seller, my lord. That means, my lord, they have received an amount of rupees 58 lakhs. It is not shows, my lord, whether the entire 58 lakhs is all on cash or, my lord, checks, my lord. And how much is cash and how much check.
No,
Now, my lord,
it has been written that 58 in cash and
58 lakhs in cash and
Ah.
check. That means, my lord, 58 rupees, my lord, there some part of the amount is on in cash and some part of the amount is on check, my lord. They have received. Now, my lord, the money recovered cash amount is, lordship, 70 lakhs 88,000, my lord. And 43 lakhs rupees of check amount of 43 lakhs of rupees also seized, my lord, of various banks, my lord. It is not only one check, my lord. So, my lord, this is not telling, my lord, whatever my learned friend is submitting, my lord. Because one land they have sold in the year 2018, my lord. So definitely, my lord.
Kindly go through that.
Yes, the purchase by this person, my lord. Purchase by this person in the year
No,
2018. my lord.
now what he is submitting that this particular land was purchased by him in 2018
18.
and later on this date it was sold.
Not sold, my lord. It was made an agreement to
So
sell.
agreement means
The
agreement.
question is that, my lord, what is the total consideration? 60 lakhs, my lord.
No,
The recovery is 1 crore 13 lakhs, my lord.
one thing, another thing, I mean, we'll have to consider, everyone is aware who are sitting inside the court that this is the shown value.
Yes, my lord.
Correct. I mean, always
The
you don't.
question is that, my lord, for the investigation purpose, my lord, we cannot, my lord, presume, my lord. The 60 lakhs is the, my lord, the government value. My lord, we cannot say, my lord, because, my lord, whenever initially they were interrogated, my lord, they could not say, my lord. They could not say, that is why, my lord, they were taken to the police station along with the, my lord, money and checks, my lord. Then they have revealed all these statements, my lord.
But these documents were seized at that time only.
No, on that day itself, my lord. But initially, my lord, when yes, my learned friend is correct, my lord. If there is, cannot be an offense, my lord. If a person carry lakhs or crores of rupees, my lord. But he have to reveal the source, where from he has carried this money, my lord. It is not an offense, my lord.
It's an income tax case, my lord, if we fail.
Now, my lord, during interrogation, they have stated, my lord, that we have got this money by doing a agreement for sale, my lord, and we are going to, my lord, hand it over to in a place calling Killing, my lord, in the state of Meghalaya, my lord, to some Islamic fundamentalists, my lord. Now, my lord, whatever section 17 says, my lord.
First
Section
of all, that
17
fundamentally has to be there, my lord. Who is the group? Who is the extremist
No,
group?
that is
And the
I'm-
killing
that
is the
that is
USTM
I'm-
itself in the
that is I'm
killing.
submitting, my lord.
And they are saying that my lord, they cannot presume it, that is the legal source. And they can presume it, that we are giving it to the extremists, my lord. And 22 days, you are investigating. What material you have collected, these
Let him
and they are
complete.
saying that the only basis of our statement,
Let him complete.
it is our statement only.
Let him complete.
My lord, section 70 says, my lord,
What-
punishment for raising funds for terrorist act, my lord.
What?
17, section 17 says, my lord,
Huh?
punishment for raising funds for terrorist act. my lord.
Hmm.
Now, is the first order is, my lord, whoever, my lord.
Then first you'll have to read terrorist act, whether it's
Yes,
a terrorist act,
Yes. Section
whether any
55
element of terrorist act is there. If
Yes.
terrorist act is there, then it will come punishment for raising funds for terrorist act.
My lord,
First
punishment
we'll
for
have to,
terrorist act, my
we'll
lord.
have to prima facie satisfy.
I think that too, we have to give it a schedule, the terrorist gang, because there is a schedule, not to all group, my lord. There is a schedule also. Who are the terrorist group?
My lord, whoever commits a terrorist act,
Only
shall,
fundamentalist word will not do, my lord.
No,
whoever commits a terrorist act shall, now clause A, my lord, if such act has resulted in death of any person, be punishable with death or imprisonment for life, and shall also be liable to fine. In any other case, my lord, be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and also be liable to fine. That means, my lord, whoever commits a terrorist act shall, in case of death, first, that is
No,
not
Mr.
applicable to us, my lord.
Understood. Mr.
Other
Bo-
thing, my lord,
No,
in
understood,
any
Mr.
other case.
Borua. Now, only thing is that prima facie, you'll have to be satisfied that there is a terrorist act involved. Correct. So you'll have to first, yeah, you'll have to first comply the definition of terrorist act,
Hello.
whether terrorist act is involved.
Hello.
If terrorist act is involved, then the second section will come.
My lord,
So
question
is there
that,
any
my lord.
material? Is there any
My
material?
question is that, my lord, that is why I'm submitting, my lord, from the starting of my submission only, my lord, that it is in a very nasal stage, my lord. It requires further investigation, my lord. And my lord, the other investigation, my lord, some report are yet to be received and obtained, my lord, by the investigating authority, my lord. So my humble submission, my lord, that a case diary be called for with up-to-date, my lord, entry, my lord. What are the other materials, my
You
lord?
are sitting with the case diary, now
No,
you are
no,
asking
we
for
have-
it.
We have received the case
Yesterday.
diary yesterday, my lord.
And that,
So I took some time, my lord, because I want to
what
also
up to date,
clarify.
my lord, 28 days, what up
Clarified,
to
my
date
lord.
case diary, my lord? What up to date case diary, 22 days?
Because it
You were
requires
sitting
further
over it.
investigation, my lord.
What further investigation? You have failed. Whether you have inquired, Lordship, kindly see whether they have inquired, whether they have investigated, whether the first cell deal, which they have recovered, it's a false or correct, whether they have inquired in last 22 days. And he said that this is a cell deed, it's not carrying. Alright, this is a cell deed on that day.
Okay, give it a CC.
Lordship kindly see that the money has been exchanged on that day. What kind of a submission is this?
That is true, my lord. But
Then
there has
that
to be,
is
my
what
lord,
remains.
60
It's-
lakhs money
Yes.
and recovery money is different, my lord.
So what? I can have a more than the 67 lakh which suppose I have carried 5 lakhs extra, my lord, in my pocket. I have to explain everything. If that is fail, I'll be liable for anything under the Income Tax Act. It is not a case of Income Tax Act. You are alleging a terrorist act. You must to establish that you cannot take away my rights by just saying that the fundamentalists. Which fundamental group to whom we are planning? Last 20 days we will sitting over the investigation and now we'll say it's a nascent stage. It's a so many important case and you are not doing anything. It's a terrorist act and you are sitting over the case diary. Absurd proposition, there is a limit to everything. Everybody knows what was the purpose of arresting these people. I don't want to say in the open court. If I had the intention first, the all checks, I'll going and I'll withdraw, first of all, to give it to somebody.
All the checks were issued by this Mustafa only.
Mustafa, he is in different, wife and relative, they have.
All issued by
Yes, yes.
Mustafa.
They have issued, my lord. It is their checks, my lord.
You all were arrested when? Which was the date? I just forgot the date.
Same day, my lord, 28.
28, 1.
One. In evening, my lord. From submission, it is apparent there is no link till today.
Yes.
So, my lord, this is my humble submission, my lord. Let the investigation go, my lord. So it is in a nursery stage, my lord, and they could not, my lord, say, my lord, actually, what is the source of the entire money, my lord? 1 crore 13 lakhs
Yes,
88,000, my lord.
Absolutely correct, man. That day we have purchased, we have shown it is a registered sale deed, not at all an agreement also. How the burden will shift to me, my lord. First, you have to establish it's not you have apprehended me. It is your duty last 20 days that as we have failed to show that how money is involved, how we have collected the money, that means it's a terrorist act. Only because of some titles, you can presume it.
So other than the confessional statements, there is no other material.
Other material, my lord, they could not say the source, my lord, where from they've got this
Why?
money, where
Why
from
we
they
have seen the source, my lord? We have showed it the source.
So
You have collected the
Lordship taken
document.
into consideration the, my lord, agreement for sale, my lord.
Yes.
It is a agreement for sale of 58 lakh rupees, my lord, they have received on that particular day, my lord.
And the checks?
Then what about the other? That is a
How much?
58 lakhs is including the check, my lord.
So
58
15 lakhs extra money you have got it from us, admittedly. Let us 20 lakhs, let us 30 lakhs. Just because I have failed to explain where the 30 lakhs comes from, I am a terrorist. I am linked with the terrorist. What is an absurd proposition, my lord? And you are relying on last 20 days only on our statement. You have not investigated anything regarding our credentials, my lord. What we are, what is our past history. You could have interrogated the person in the meantime from whom we have purchased the land, whom we have sold the land. It is a genuine or not? Everything is genuine, my lord. Just because our surnames, we are before in the custody.
and 4 persons were together, my lord.
Yes.
My under submission.
Yes. We cannot travel in a 4-person, my lord. What a beautiful. A car can be provided for 5-seater, 4-seater, but we can't travel in a 4-seater. A driver is also there. I can travel with my friend. Oh, that's an offense nowadays in India. So we have to stop coming in for together tomorrow. Lawyers should be also, and you should be also. Don't travel in 4.
I drive myself, man.
So
He travels alone, he's saying.
he's very clever. He knows the law. Rest of us probably we don't know the law.
You also travel alone, I have seen you.
Car is different, man. Car is different.
Car is different. So, okay, we'll close this then. Nothing else is there, no? Is there, what is this case all about?
Justice Malad, there has to be paragraph 26, the accused statement, nothing. There has to be reasonable ground.
One second, para 26.
Para 26, Court has to found reasonable ground for believing, very strong material is reasonable ground for believing that the accusation is prima facie true. That's very important, man. Then only they can keep him in custody, otherwise no. Otherwise, the accused is entitled to bail, man. 38, 39, 50, also
Then other paragraphs?
38, 39, 40, I'll not bother your lordship, lordship will go through definitely, 41, 44, 46.
No, 33, 38 on what?
38, 39, 40 facts
Of this instant.
of this
A
particular
particular
case, my lord.
case. And,
not
and
collected.
41? Funds. What is
Fund,
41?
fund, 41. How
What-
fund is,
Let's see 41.
yes, 40 also, my lord. Here, in this case, bail was granted because the charge was not under 40.
41, the act of raising funds.
Yes,
that is
in this
mentioned
case,
in
it is
the-
not there.
The separate offense.
Yes, it's a separate offense. They have to add separately. In this case, it is not there like in our case also. Because otherwise 17 does not fall. Problem is 17 does not fall.
Section 40 is not added in your case.
No, not at all. Probably IO has forgotten to add 40 and he was busy whether we are traveling in 4 or 3 rather than adding 40.
There is no bar, my lord. During
Absolutely
investigation,
no, but I'm
my
not
lord,
saying that till
we
today,
can add many more.
20 days you have not added 40. That's why I'm saying he has forgotten to add 40 because he is busy.
40 would have been more relevant in the facts and circumstances of the case.
If the allegation is that 40 is more irrelevant.
Let the investigation proceed, my lord. So,
Definitely investigation. We are not in the quashing of this case. Investigation, but you cannot just because we have failed. And this is not a case of failure also. Rather, we have proved the case.
So in this case, bail was, bail was not given. That was quashed.
Even, yes. As the stringent condition imposed on section 50 do not negate the power of the constitutional court.
whether, my lord, this is the case, my lord, during investigation or, my lord, after conviction, my lord.
No, I am on the parameter of the
No,
material.
it says about,
In charge sheet, when the charge sheet was filed,
why don't you give me a copy also?
Question is that, my lord, my case is, our case is distinguishable, my lord. Because this is.
no, I am on
stage
not
of
that.
investigation.
The while granting bail, I am on that.
And while granting bail,
While
what
granting,
are the
parameters?
parameters that that a constitutional court needs to look into? So that is what.
That is only what we are saying. Other facts are not important. What are the parameters here? Parameter is there has to be reasonable ground for believing for the court that there is a link.
That's all, anything else?
No, madam.
So we'll pass the order,
Lordship also can go through this. Initially, there is some agreement with the parties, but it's not relevant because it's not, that is with the USTM, with the petitioner regarding the investment.
okay, it was done when?
It's long before, my lord. Long, in December 25, a month back.
ERD Foundation is.
Yes, that is the USTM.
Okay.
Parent organization. Contribution of payment, what you will find.
Okay, right, heard Mr. A.M. Bora, the learned senior counsel, senior counsel assisted by Mr. D.K. Boddo, the learned counsel appearing for the petition in 45, 44 and 45, for the petitioner. Also heard Mr. R.J. Bora, learned APV for the state. Hearing concluded. the order reserved. Then
My lord, learned friend also.
other case 43, right? I heard Mr. M.
Mistake.
MSC, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Borwa, learned APP for the state. Hearing concluded, order reserved.
Obliged.
Mr. Borwa, you don't have anything else to say on that, that's all.
My lord.
You don't have anything, anything to add on? That's-
That is, my lord, my humble submission is that my lord, investigation is going on, my lord.
Mm,
And if
that's
Lordship
good.
grant them, my lord, absolute bail, my lord, it will hamper in the investigation, my lord.
Lordship had directed me to produce the case diary. Unfortunately, Lordship, it is not with me. I'd be requiring some more time for the case diary, but I would just like to draw your Lordship's attention to the investigation so far as the accused is concerned. Lordship, I have marked it. His complicity in the matter would be evident from that. I've flag marked it. It would be on your Lordship's left-hand side page. Right? Actually, he had been to Manipur, then he had seen the material and he was to receive it in that hotel where he was.
Your ground is?
My lord, my submission on two leg, one on factual aspects and merits and on legal aspect, violation of 47, 48, Article 22(1), my lord. And my lord, factual aspect, what happened, my lord? According to their own, my lord, records, my lord, I was telephoned, called by the officials when I was staying in the hotel. They apprehended those other accused, my lord, with in the vehicle at 0.25 a.m. on 14th, my lord. And I was rang at around 8:30 in the morning in the hotel, my lord. I was asked about whereabout. I told I was waiting for them. Then they came. Then they, my lord, took me to their office, my lord. Had I been, my lord, been enrolled, I could have run away, my lord. I would have been informed by 3, 4, or many of them, my lord. And I could have run away while they have informed me over telephone. It is admitted position that they have informed me over telephone, asked my whereabouts, my lord. And my stand is that, my lord, I came here for my medical purpose as well as for the purchase of some computer materials for my son who is going to open a shop of computer repairing in Ilambazar, Karimganj, my lord. And my lord, it is a fact that, my lord, my father-in-laws, through my father-in-laws, I know one Yakub Ali, my lord, of the third accused perhaps, my lord. And I know him, my lord. And my father-in-law rang me, and also, my lord, he rang me also. Are you coming into Gauhati? Yes, I'm coming to Gauhati. Please help me he is to go to the Apollo hospital. He has undergone a major operation, my lord. Kindly see the documents of that Yakub Ali. They have not seized, my lord, till with the accused in the jail, my lord. Kindly see the, my lord, series of documents of earlier, my lord, not that it is later on or immediately, my lord. A series of documents I have annexed, my lord. Page 28 to 29, 35, my lord, 36. My lord, kindly see, he has undergone operation, Yakub Ali. He told me he cannot speak Assamese, so I had to help him, my lord. Also, I have come from my own purpose, and that only on that call record, perhaps they checked that their records and found me, my lord. And had I been, my lord, as remotely input, I could have run away, my lord. Even after that, their calling also, my lord. It is admitted position that they have called me, they came to me, then I went with them. And my lord, there is no record to show that I have any connection with the transactions. I have any connection of CDR, anything. Nothing, my lord. And the Honorable Supreme Court, in many cases, your lordship is aware of, my lord, even CDR call is there also, my lord, bail should be granted, my lord, if they cannot corroborate with other evidences, my lord. And there is not as, my lord, minimum prima facie evidence against me, my lord, only except statement under section 67, my lord. And my lord, your lordship, if your lordship goes to the 67 statements, voluntary statements, statement of everyone is same, almost in toto. My lord, can it be possible, my lord? And my lord, all the question answers are same. My lord, all class up to class, read up to class 10, my lord. And I have specifically made, my lord, submission in my, in my petition, my lord. If any, they could show that I am educated, that I can read in English and Manipuri well, as they have stated in the 67 statement, my lord. Whether they can show any link, they have seized my lord, bank records, my lord. That is ATM card, my lord. Also, but nothing will be found, my lord. And my lord, this is the, my lord, legal aspect, my lord. They themselves, my lord, saying that I was in the hotel, they rang me, they called me, known about my whereabouts, then they came to me, my lord. From night, I could have been informed by the co-accused, my lord, had I been involved with them, my lord. Any of the accused, my lord. But not, my lord. On the other hand, my lord, regarding section non-violation of 47, 48, my lord, this honorable court in its judgment and also Supreme Court, my lord, said that it should be in writing and in vernacular, my lord. He understands in writing that is not complied with. Number 48, my lord, to be communicated with the nearest friends or family members in writing, not complied with, my lord.
It is there, writing is there.
No,
Page 25, Lordship.
my
of the
lord,
petition
my
itself.
lord, 47 in writing is there, my lord. 48 is not there, my lord.
48 is also there.
48 is not there, my lord, perhaps, my lord.
It is there.
But my lord, it is not, my lord, there is no.
It is there.
Kindly check, my lord. Kindly have a look at this, my lord. The 48, the family members,
His wife.
they have said
It
that,
is-
my lord.
It is there. His, your wife's name is, Surya Begum. Surya Begum.
My lord, it should be informed, my lord, before being produced to so and so, my lord. That is not done. That is long after they went to their house, many days after, my lord. Perhaps around 1.5 months, my lord, or more, my lord. They went to my house, my lord. They took the signature there in, my lord. About 1.5 months later, to see whether I have any other document connection, any incriminating materials or any crimes I have committed. They went there in my house after 1.5 months or more, my lord. And then they took signature of my father and my wife also.
I don't see his father, Lordship.
And
I do not see any material of his father.
I don't know, but they took signature as I am instructed, my lord. That signature of the wife and father. They went, they sat for a few minutes in the house, in his house, talked with his father and his wife, and took signatures from some record. They are also illiterate, my lord. 5, 6 past, my lord. They do not know. The father is more illiterate, my lord. He did not put his signature only. And my lord, kindly see, they are saying, my lord, I have connection. If they can show any connection of money transaction or of anything or any call record details, where I have talked, my lord, it is up to your lordship, my lord. I do not know whether I have checked, my lord, in their conclusive findings in their charge sheet. It is only that Najimuddin have given me 20 lakhs rupees, my lord. One Najimuddin have given 20 lakhs, my lord. Even if they can show it with proof, my lord, then it is up to your lordship. Will see, my lord.
Proof will be seen by the trial court, Lordship. Lordship only has to see a.
Some materials will be collected, my lord. The charge sheet is submitted long back, my lord. And I am behind the bar about more than 7 months, my lord, for not even remotely connected, my lord. My lord, your lordship permits me, I will place some judgments before your lordship. My lord, what about the NCB, the one last order passed by the Honorable High Court, my lord? They have served the copy, bail granted on section 48. They have, this same NCB, number 7, my number is 9, other number is 8. This previous case, what they have done, they have said that they have served the 48 notice on father. Later on, it is proved that his father died 5 months before they are serving the notice. Then honorable court granted him bail.
That's a different fact.
So much, my lord, they used to lie, my lord, and makes, my lord, wrong things used to present before the honorable courts, my lord, only to implicate and to, my lord, for no reason, my lord. Only kindly see, my lord, I place some judgment before your lordship.
No, judgments are fine. I mean, that is fine.
In Holiruddin case, my lord, is clearly said, strong suspicion should be premised on some material which commends itself to the court and as sufficient to prima facie view that the accused has committed the crime. Nothing, my lord. At best, they have a.
You have seen the 48 notice. You have it.
It's not here, Lordship. I have marked it there.
You check the 48 notice.
No, it does not bear any signature, Lordship. It
Then-
does not bear any signature.
Then
Yes.
on that ground, your case goes.
Lordship, I can't help it, but it is not there. I have seen it, Lordship.
Otherwise,
Otherwise, some-
47 is fine, but
47 is
48
fine.
is not compliant.
48 is, Lordship, I am with your Lordship. But otherwise, Lordship, the investigation does reveal that his complicity is there.
But that's a mandate.
That's the mandate, Lordship.
My lord, I have marked the conclusive findings of the investigation in Abul Kalam, my lord. Nothing there, I have seen it, my lord, except saying that Najimuddin transferred some lakhs of rupees to my account. Even that much also they could not,
Perhaps he should
no
look
link,
once
nothing.
again. Perhaps he should look once again. He has seen it. I have marked it, Lordship, and the prima facie materials are there, except for the technicality of section 48, Lordship. Others are there, Lordship.
They have got the material documents of Yaqub Ali, my lord, but they have not seized it, my lord. It is with the jail. I have annexed bringing from them, my lord.
Okay, we'll pass an order.
Yes.
I mean, 48 is not complied with, so we will consider that, we'll consider
On
that.
the record, Lordship, it is, no signature is.
There is no signature and there is nothing stating that, that wife has been intimated at the time by phone, nothing.
Though we take a stand in our affidavit, Lordship, I do not find the.
There is
materials.
nothing, no material
Yes,
suggesting that a wife was intimated at the time of arrest.
Yaqub plus.
Honorable Supreme Court is very, my lord, specific. It should be in writing. It should be in vernacular, both to the accused and to
Yeah,
the.
vernacular, you forget. You have signed in English.
He is signed
lord,
in English.
You have signed in English.
That's true, your lordship.
You have signed in English.
That's true, your lordship.
So don't give those.
My lord, yeah,
Telephonic
lordship, my lord,
intimation-
kindly have a look at the, letters written, my lord. Just how,
I have to use-
know how to read, all capital, my lord. letters.
My writing was also like that, I mean,
My-
in my earlier time, days.
My lord, in that case, sir.
So far as telephonic intimation is concerned, Lordship, there is a document which says that on 14/7/2025, after arrest of Abul Kalam, he telephonically talked to his wife, Suraya Begum, on her mobile phone number so and intimated her about the details of his arrest and seizure of 10.so kg of tablets, and his signature is there. On 14/7.
It is there.
It is there, Lordship.
My signature took on many documents, my lord. I have specifically mentioned in my case, that took signature on my lord. One thing, your lordship will be very strange to see. I just come to my lord. They arrested me on 14th, my lord, admittedly. But what,
The pink color, Lordship.
So it is there, Mr. Talukdar,
my lord,
48.
my lord, as per the, my lord, Supreme Court judgments, I equal lordship.
Now
it
your,
should be in
no,
writing.
then-
It should be in writing also, my
no,
lord.
writing it has been given.
My lord, if
No, no,
48
how it will be given to somebody who stays in Manipur? And the arrest is made in
no,
Gauhati?
my lord, no, my lord.
No, you
Yes,
tell
my
me, you
lord.
tell me.
But they have
No,
went
no,
there after
No,
one and a half.
no, you tell me, if somebody's family stays in Manipur or in Nagaland and arrest is made here, how it will be served on the same time?
My lord, that is true, your lordship, my lord.
How will you do it?
My
How
lord,
it will do it?
but-
But, and the copy has been sent to you.
My lord, no, my lord, signature is taken, my lord. Only
Signature
nothing
is
given to me.
taken,
Only signature is
48
taken, my
notice,
lord.
41,
On many pages, my lord.
48 notice was sent to you, sent to your family. Then how it will be complied? You tell me that.
My lord, when they went there, my lord, after about 1.5 months, they took signature of my.
No,
wife.
but telephonically informed you.
They could have called her, my lord. It is a matter of 8 hours journey, my lord. My lord, they could have called her also, my lord. They did not. And my lord, above everything, If there is any minimum material prima facie evidence before your lordship, they could place, my lord, I will not prefer bail, my lord. Nothing, my lord. Neither even, my lord, the transaction, nor any serial call, not even any, nothing, except one call they can find only what I have taken, my lord.
Okay, we'll consider, I'll pass the order. I mean, it will take some time, so I'll not passing the order here. This is right, we heard Mr. A.K. Talukdar, the learned counsel appearing for the accused applicant. Also heard Mr. Mr. Dev Chaudhary, the Deputy Solicitor General of India on behalf of NCB. No?
Yes, Lordship.
NCB. NCB, hearing concluded, order reserved.
So nice, Lordship.
Your lordship, my lord, permission, I will show how casually they used to do, my lord. They have served a notice upon the father who had died 5 months back. This 48 notice.
There is no material here.
My lord, this is order, my lord, lordship. Your lordship permission, I can produce your lordship.
That does not relate to the petitioner, Lordship.
What is there, let's see. Whose father?
My lord, the accused's father, the
In a different case.
48 different case. 7, my lord. This is 9, NCB 9, this is NCB 8, my lord. The same officials, my lord.
There is a different
Same
case.
officials. They have served the 48 notice on the on father who died 5 months back.
But that's a different case. Anyways.
My lord, this is the way, my lord, they used to, my lord, produce the documents before your lordships, my lord, and post, my lord. So casually, my lord. And Supreme Court is also very clear, and your lordship, my lord, honorable courts in other courts also, my lord, very clear that it should be in writing. 48 should be in writing. 47 should be in writing. my lord.
It is writing. But only thing is that, I mean, you were not there. I mean, your family is not there.
My lord, they detained, my lord, they could have detained for some civil hours and could have been told also, my lord. And above all, my lord, if there are any materials, my lord, kindly have a look. If any materials against me, any prima facie materials against me, my lord, I will not pay. It is up to your lord.
I'll look it and consider.
Apply.
15.
May please your lordship. Lordship, this is a regular bill application. Your office note indicates that service is awaited on RTO.
No, that report we have not received even today also, my lord. On the last occasion also, my lord, we were directed to obtain instruction.
Service on respondent number 2 is yet to be completed. Both sides are represented. Let the matter be fixed on in the first week of March. Let the matter be fixed on 6th of March.
My lord.
Oblige, your lordship.
16.
My lord, service completed, my lord. Service report is complete, my lord. 85.
But very recent.
Scan copy.
Are you appearing? Are you appearing?
My lord, scan copy received, my lord, service complete. Now your lordship would be pleased to see the FIR, my lord. My lord, petitioner is in custody, my lord. Search sheet has been submitted 253 days, my lord, as on today. 253 days, my lord. And another point your lordship will consider that PW2 is the victim, my lord. And her statement was recorded. His statement is recorded, my lord. And informant's statement is also recorded. My lord, as per Supreme Court decision, my lord, that in POCSO case, there is some bar. Bar regarding, my lord, before examination of the victim, bail should not be considered and granted. But in my case, my lord, already victim is examined, my lord. I'm referring to page 52, my lord. Victim's statement, my lord. So, my lord, my humble submission before your lordship regarding allegation, my lord. Allegation is very serious one, my lord. I'm not on that. That I am to face the trial, my lord. If the conviction comes, I am to face it. But the thing is this, my lord, after 253 days, my lord, when victim is already examined, informant also examined, my lord, further detention is not necessary, my lord. And my lord, let me face the trial by engaging advocate, my lord. that much is my submission, my lord, that may be considered.
How many witnesses are there?
There are around, my lord,
Where is this charge sheet?
Charge sheet at page 19, my lord. Page 1926.
five, my lord, five.
But other, here, my lord, in the case, nature of the case, my lord, doctor is a vital witness, my lord, he will be examined, my lord. But thing is this, my lord, already victim is examined, informant is examined, my lord. Except doctor, my lord, other witnesses are not so much important. But I have permanent resident, my lord, there is no chance of absconding, my lord. Let me face the trial, my lord, what consequence will come.
There are 9 witnesses.
My lord, there is no chance of tampering with the victim, my lord, this informant, my lord.
Difficult, Mr. Sheikh.
My lord. My lord, the allegation is serious, no doubt, my lord, but
Serious allegation and
my humble submission,
Yes.
Your Lordship, only the detention period, my lord.
detention is correct. I mean, you are right in that 253 days happened, but like it's POCSO matter. I mean, that too, I mean, unnatural, this thing, activities. It's not natural also.
My lord, on this,
Yeah,
point,
and
on
see,
this
the
point,
victim is a young boy without having a father,
that is there. my lord.
13 years boy.
But here,
13 years boy.
here, my lord, one thing. My lord, that
Mr. Sheikh, it will be difficult at this
my
stage.
lord, at this stage, my lord, all right, only thing is this, my lord. Regarding this POCSO, my lord, whether the POCSO will apply to the
That you were already,
male, male person, my lord.
you are already on trial.
My lord, my
You are
lord,
already on trial, so
my lord, your lordship, while POCSO will apply to the male person, my lord,
Yes, yes,
that
but
is under consideration of
when
the
is the
Supreme Court,
bar-
my lord. That point, my lord. Because that point is before the Supreme Court, my lord.
he's correct. There are something is going on that. But at this stage, Mr. Sheikh, I mean, it will be difficult. I heard Mr. M.A. Sheikh, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Burwal, learned APV for the state,
M. Ahmed.
and Mr. M. Ahmed, the learned. You have anything to say? You're opposing or supporting him? Huh? No, I mean, you must be having some instructions. Yeah, I mean, you are representing, right? You are not amicus.
No, I have
So what is your instruction? Also heard Mr. M. Ahmed, the learned counsel, appearing for respondent number 2, the informant, full stop. There is an application under so and so. You write that, huh? An FIR was lodged on 10/6/2025 by the informant alleging that that the victim boy is his nephew. And the accused applicant, who is the headmaster of a madrasa, called the victim boy to his room and engaged him to massage his body. And during such activities, he has committed rape on the accused, or a rape on the victim boy. Full stop. On receipt of the FIR, police registered Moirabari PS case number 96/2025 under sections 140 in bracket 3 of BNS 2023, read with section 6 of POCSO Act. Full stop. Subsequently, the accused applicant was arrested and he was sent to jail hazard on the same date. Full stop. After investigation, the police filed charge sheet number 90/2025 dated 30/6/2025 under sections 140 in bracket 3 of BNS 2023, read with section 6 of the POCSO Act against the accused applicant. And Mr. M.A. Sheikh, the learned counsel appearing for the accused applicant, submits that the accused applicant is already in jail for last 153 days, and the informant as well as the victim boy has already been examined before the trial court. Therefore, he submits that, taking into account the length of detention as well as the fact that two of the most important witnesses have already been examined, this court should grant the accused applicant bail at this stage, as further custodial detention may not be required in the instant case. On the other hand, Mr. R.J. Burwa, the learned counsel appearing learned APP for the state, has submitted that there are sufficient materials against the accused applicant of his prima facie involvement in the instant case, and many of the witnesses named in the charge sheet are yet to be examined. Therefore, at this stage, bail should not be granted. Mr. M. Hussain M. Ahmed, the learned counsel appearing for the respondent, has also supported the submission made by the learned APP. Full stop. This court has, the trial court, TCR in the instant case has been produced before this court, and the same is perused. Full stop. After hearing the submission made by the learned counsel appearing for the parties, this court is of the considered opinion that at this stage the bail should not be granted to the accused applicant, and accordingly the instant bail application is rejected. Not at this stage.
Not only one sentence I will pray before your lordship, that the learned trial court maybe expedite the trial.
It will be done, Mr. If it is, if it is delayed, undue delay happens, if approach this court, we will. But this kind of cases usually, so already two they have examined. It will be concluded. Don't worry.
What I submit before your lordship, if your lordship kind enough to write this sentence, my lord, then it will give a signal to the trial court, my lord, for.
It's not delayed, Mr. Sheikh. Yeah, had it been unduly delayed, it would have been done, but it's not delayed. You see, you are there in 153 days, and it's already two examined. You cannot expect more faster than this. You are aware of this, Mr. Sheikh. Sure.
17.
Your lordship, the petitioner is in custody now is 76 days, your lordship. Lordship, kindly peruse the FIR, lordship.
What offense?
My lord, lordship, 103. Basically, my lord, 103, my lord. 238, my lord. Kindly peruse the FIR, my lord. 13, my lord.
CD has come.
Yes, that has come, my lord, without the postmortem report, my lord. Even on the last occasion also, my lord, lordship was directed us to, my lord, obtain the postmortem report, my lord. But we have contacted the investigating officer, my lord. postmortem report, my lord, is not ready, my lord, as per his information, my lord.
Today is 78 days, my lord, for a moment, my lord.
103 master.
No, my lord, kindly look into.
No, no,
my
103 meter.
It does not mean that I am involved, my lord. For a moment, my lord, kindly peruse the FIR, my lord.
103,
For a moment, my
103.
lord. For a moment, my lord. My lord, page annexure A, page 13, lordship.
Who are you? Jamal Ali.
Yes, lordship.
Yes.
I'm a father, lordship.
Huh?
Father, lordship.
You are the father of the accused. Or what?
No, my lord. I am the respondent number 3, accused number 3, lordship.
Yeah, accused number 3 is who?
I am a father, lordship.
Father means whose father? You will be a father. Everybody is a father. Who is a
Yes, true,
who
my
is a
So
I mean, other.
according to him, my lord, that
He is the father of the, my lord, other two accused person, my lord.
accused person.
That you say that
Kindly for a moment, my lord. That is it, my lord, page 13, my lord, annexure A, lordship. With due respect, I beg to inform you that the accused number 3 has taken an amount rupees 5 lakhs from my father, Zahlaluddin, to promise to sell a plot of land about 1 year ago, but not sell to the land, and my family 5 members, father and mother, along with the sister and brother, had been staying in the accused residence.
okay, that case. So I mean there was a promise of selling land, then
No,
land
my
was
lord,
not sold.
allegation, my lord?
Not sold,
Allegation
no?
is the next page, my lord.
Yeah, understood.
It is a very civil nature, my lord, but second part is, my lord. Page 14, my lord.
Mr. Borua, what is there?
Well, kindly peruse that CD, my lord.
Otherwise, my lord, there are materials, my lord, because, my lord.
Nothing, I mean, nothing much.
Victim, my lord, victim was, my lord, given some threatening, my lord.
Correct, I mean,
And he is also, she's also having some affair with the, my lord, accused number 1, my
You are coming only for the father, right?
Yes, lordship.
Huh?
No,
Yes,
father
and other also, my lord, 29, my lord.
apprehending arrest, my lord.
29 and 3, my lord, 30, my lord. In this case, my lord, what happened? Kindly look into that. What allegation, my lord? There is no eyewitness, nothing, my lord. Page 14, my lord. For a moment, my lord. No eyewitness, nothing, my lord. 14, my lord. Paragraph second. On to 12:25 about 11 p.m., accused number 1 allegedly entered our house, taking advantage of my ill father saying hello. When my father tried to drive him away, accused number 1 allegedly made him unconscious by giving him a substance through a cigarette, my lord. Can it believable, my lord? Thereafter, all the accused person allegedly killed my sister and tried to portray it as a suicide by hanging the dead body, my lord. No eyewitness, nothing, my lord. It is admitted position, my lord, that bail is a rule, my lord, and custody is a, my lord, exception, my lord. Only because, yes, my lord, civil dispute is going on between the two families, my lord. It is admitted position, my lord.
Mr. Borua, let him go. Nothing much. Is there anything?
My lord, whereas, my lord, he is the person, my lord, who has informed that, my lord, the victim has committed suicide, my lord.
Correct. And they have only, I mean, they have only.
Regarding, my lord, land dispute, my lord, I am not going into the, my lord, land dispute matter much, my lord.
But at this stage, 76
And he is-
days already gone.
And his son is having some affair, my lord, with the victim, my lord.
And some serious land dispute. At this stage, Mr. Borua, let him go.
But the other accused person, my lord, I have objection, my lord, who are apprehending arrest.
No, my lord, in this case, my lord.
Heard Mr. D.
K.
Das. K. Das, the learned counsel appearing for the accused applicant. Also heard Mr. R. J. Borua, learned APP for the state. This is an application under so-and-so. Allegations as narrated in the FIR dated 4/12/2025. That the accused, that one Jamal Ali, accused number 3 in the FIR, had taken an amount of rupees 5 lakhs from the father of the informant, with a promise to sell a plot of land about 1 year ago, but the same was not done, and the informant's family of 5 members, including father, mother, had been staying in the house built in the land of the accused persons for the last 1 year. Ahmed Ali is the main accused, right?
Yes, according to allegation that, my lord.
For 1 year. It was alleged that the accused number one, that is Ahmed Ali, had a love relationship with the complainant's minor sister, Sahida Khatun, who was about 17 years and 6 months old. It was alleged that on 2/12/2025 at about 11 p.m., the accused number one, that is Ahmed Ali, allegedly entered in their house and taking advantage of the ill health of the father, father, and after making him unconscious by giving him a cigarette mixed with certain substance, allegedly killed her sister and tried to portray the same as suicide by hanging the dead body. It was alleged that the accused number one
Intend to marry
another woman, and that was the reason why the victim girl was killed by the accused persons. The learned counsel, Mr. K. Das, the learned counsel, appearing for the accused applicant, submits that the whole case has been falsely made by the accused, by the informant and her family, due to the fact that there is a dispute about monetary transaction going on. It further submits that there is no eyewitness in the instant case, as well as the story that has been portrayed in the story that has been narrated in the FIR is unbelievable. Full stop. He submits that the accused applicant is already inside the jail for last 76 days, and he is how old is he?
Is it 55 years?
Okay, so 76 days, and he is no way involved in the suicide of the victim girl. Therefore, at this stage, taking into account the facts of the case, as is apparent from the FIR, this court should grant bail to the accused applicant. Full stop. On the other hand, Mr. R.J. Barua, learned counsel, appearing for the accused applicant, on the basis of the case, there is submits that there are incriminating, there are many incriminating materials against the accused applicant of his involvement in the instant case, and at this stage, and therefore at this stage, the accused applicant should not be granted bail. This court has heard the submission made by the counsel appearing for the respective parties, as well as gone through the case diary. On taking into account the length of detention, as well as length of detention, as well as the contents of the FIR. This court is of the aforesaid view that at this stage, the accused applicant should be granted bail. Accordingly, it is directed that the accused applicant should be released on furnishing of a bail bond of ₹30,000 with a security of like nature, to the satisfaction of the each court.
Judicial Magistrate First Class.
Judicial Magistrate First Class. Hajo, subject to the following conditions: the accused applicant shall cooperate with the investigation. Accused applicant shall not try to get in touch with the family of the victim girl by any manner. That number 3, the accused applicant shall not try to influence any witness that may be involved in the instant case. In view of the aforesaid, the instant bail application is allowed.
Item number 29 and 30.
Connected matter, no?
29 or 30.
Uh, 29 is Ahmad Ali, my lord,
And 29 is Monir Ali, my lord. Young, elder brother, my lord, of Ahmad Ali, my lord. Who is staying in different place, my lord.
Who is staying in different place?
My lord, accused number 2, my lord, Monir Ali, with his family, my lord.
Ahmed Ali,
Ahmed Ali is staying with them.
Is having some relationship.
But my lord, Monir Ali is, my lord, staying in different place. He is a married boy, my lord. With his family, my
okay,
lord.
Ahmed Ali, we are not giving anything.
Then, my lord, PM report may call for, but Monir Ali, my lord, he is a married man, my lord. On that occasion, my lord, he
Okay,
was
this right in item number
29, my lord.
29, you write.
No, 30, Monir Ali is 30, my lord.
Monir Ali 30, my lord.
No, 29 you write first. 29 you write, the postmortem report in the instant case is yet to be received. Both parties are represented. Let the matter be listed on.
From Hali.
2, 3, my lord.
2, 3.
2, 3.
2, 3.
Is it, my lord,
Monir Ali is one of the brother.
Yes, my lord, who is staying in different place, my lord, with his family, my lord. He is a mailman, my lord, and falsely implemented his name, my lord. He is ready to cooperate with the investigation, any condition, my lord. Is no, nothing, my lord, is against him allegation, my lord. In the FIR, lord. His lordship. Same FIR, lord. His lordship. 2019 lordship. FIR, lordship.
Heard Mr. K. Das, the learned counsel, appearing for the accused applicant, also heard so and so. There is an application under so and so. FIR, you write the same thing, okay? Write the same thing. The learned K. Das, the learned counsel, submits that the accused applicant is one of the family members. One of the family members of the accused number. No, you write like this. The accused applicant is the brother of the accused applicant, accused number 1, and son of accused number 3. He submits that the accused applicant does not stay in the house of his parents, but he stays in a different place. However, only because he is a family member, he has been also roped in, and his name has also been mentioned in the FIR. He submits that he is no way linked to the offense as alleged in the FIR, and he is willing to cooperate with the investigation. Mr. R.J. Burwa, the learned counsel, however, in the learned APP, however, opposes the bail of the accused applicant at this stage. Full stop. Taking into account the whole facts of the case, as well as on perusal of the case diary, this court is of the considered opinion that the accused applicant should be granted the privilege of pre-arrest bail at this stage. Accordingly, in the event of arrest, accordingly, it is directed that in the event of arrest of the accused applicant in connection with the instant case, he shall be released on furnishing of a bail bond of rupees 30,000 with a security of like nature, subject to the satisfaction of the arresting authority, subject to the following conditions. Number 1, the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. The accused, number 2, accused applicant shall cooperate with the investigation and shall not try to get in touch with the family members of the victim girl in whatsoever manner, full stop. In view of the aforesaid directions, the instant AB application is disposed of.
May it please your lordship. The petitioner hearing is, my lord, behind bars since 38 days, my lord, in connection with Umangshu PS case number 3 of oblique 26. Allegation is that, my lord, he has shared a obscene post relating to goddess Kali, my lordship. Actual fact is that, Lordship, neither I am the originator, neither I am the creator of this post. Lordship. This post was shared from my mobile handset, which has already been seized by the police.
He have posted one Facebook update, my lord. Lordship, kindly see there what is the update, my lord.
What is, how many days you were there?
38 days. Lordship.
38 days.
Lordship. That post was made by someone else, Lordship, and it was shared from my mobile, not from my Facebook account. I'm not the creator of this post. Lordship.
He has, my lord, insulted Goddess Kalima, my lord, in his Facebook post.
Before the arrest, Lordship, he was paraded throughout the town, Lordship. The
Heard
garment of-
Mr. Y. Borbuhe, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Burwal, the learned APP for the state. It is an application under so and so. An FIR was lodged on 12/1/2026 by one Sudarshan Johari.
Sudarshan Johari.
Sudarshan Johari of PS Umrangso. Before the Umrangso police station, alleging that one Shahzab Alam,
Shahzad Alam. Spelling is mistake.
one Shahzad Alam, the in bracket accused applicant, posted one posted one picture depicting posted one picture which on the Facebook which depicts obscene which depicts the Hindu religious which depicts anti-Hindu religious sentiment. Full stop. It was alleged that the aforesaid picture went viral and therefore the FIR was filed to take action against the accused applicant. On receipt of the FIR, the police filed Umrangso PS case number 3/2026 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that he is not the person who has posted the offensive material in the Facebook, and he's already behind the bars for last 38 days, so he should be granted bail at this stage. Learned case diary in 9th case has been produced before this court, which has been perused. The learned APP has opposed the prayer of the accused applicant for granting bail. So, after perusal of the case diary, this court is of the considered opinion. After perusal of the case diary and having found prima facie very objectionable material depicting a Hindu goddess in an obscene picture, this court is of the considered opinion at this stage the bail should not be granted to the accused applicant, and therefore this bail application is rejected.
May it please your lordship. Your lordship, already charge sheeted matter. The person is behind the bar since 126 days. NDP 126 days behind the bar. Originally behind the bar since 177 days, because he was originally arrested in some other case and then shown arrested in this particular matter, your lordship. Here, your lordship, intermediate quantity, the quantity which was recovered neither from his person in possession, but from his house, your lordship, allegedly. He is not from his possession. It was only 15.67 grams, your lordship. Thereafter, charge sheet has been filed under section 27A of the NDPS Act, which indicates towards trafficking of drugs, your lordship. However, there is no such materials in the charge sheet which indicates that any cash amount was recovered or there is any indication which links to any kind of trafficking or funding the trafficking, your lordship. The accused petitioner is 20 years of age, your lordship, and he is as per the charge sheet itself says he is a laborer by profession, your lordship. He does not have enough fund to even fund any kind of his own daily lifestyle, leave alone NDPS substances, your lordship. 126 days behind the bars and already charges have been framed, your lordship. May the petition be considered, your lord.
Recovered from his possession, my lord, he and his wife, my lord.
No, not your lord. Your lordship, the FIR clearly indicates that he was not in the house. It is mentioned in the FIR as well as the charge sheet.
Lordship, peruse the Caesar list, my lord.
Page number 16, your lordship, last line of first paragraph, it says that Puja Kumari, wife of Akash Mahato, and Akash Mahato had fled from the spot, which means they are alleging that he had fled from the spot. Recovery was not made from his possession.
It's an intermediate quantity.
Intermediate quantity, only section 27A is the difficulty before the trial court, your lordship, which said that 37 would have been attracted and therefore the bail was rejected before the trial court, your lordship. I am ready to face trial and already charges have been framed, your lordship. May my length of detention be considered, your lordship. Anecdote
21B is there, 27A is there.
27A, your lordship.
That's a heroin.
Heroin, your lordship. Intermediate quantity, however, not from my possession, your lordship.
The heroin in your house, you are a daily laborer. How heroin landed in your house?
That part would come up in the, as a part of the trial, but prima facie, your lordship, there is
No.
Let some
allegation-
witnesses be examined, my lord.
Hmm?
After examining few witnesses, my lord, let this bail application.
How many evidence are examined till now?
My lord, 9 witnesses, my
Nine
lord, in the search sheet.
Now 9,
9 witnesses, no, my lord, evidence has not yet started.
not started. Is it?
13 was the last date fixed, my lord.
Heard Mr. So-and-so. Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Borua, learned APP for the state. There is an application under so-and-so. The allegation in the FIR dated 26/8/2025 is that 6.22 grams. Total how much?
Total is 15 grams, your lordship, 15.67.
15.6 gram. 15.67 grams of heroin has been recovered from the house of the accused applicant and his wife, one Puja Kumari. On receipt of the FIR, police registered the Lanka PS case number 49/2025, registered under the aforementioned sections. After investigation, police filed charge sheet. Charge sheet number 216/25 dated 29/10/2025 under section 21(b)/27A/29 of NDPS Act. The case is pending evidence before. The charge has already been, right, charge is already been framed and the case is pending trial, full stop. The learned counsel appearing for the accused applicant submits that nothing has been recovered from the possession of the accused applicant, and he is a daily wage laborer of 21 years of age and already spent 126 days behind the bars. Therefore, he should be granted bail at this stage. The learned APP, on the other hand, opposes the bail application. Case diary has been produced before this court, which has been perused by the scan copy of the case diary. Scan copy of the PCR. has been produced before this court and which has been, which has been seen by this court. uh, After taking the entire facts of the matter and the materials before the TCR, this court is of the considered opinion that at this stage a bail to the accused applicant should not be granted. Accordingly, the instant bail application is rejected.
Deeply.
Please, your lord. Thereafter, the petitioner was arrested on 8/12/2025, lordship. And since then, he is in custody that today, as on today, lordship, 75 days. FIR, your lordship will find page 9 and 9. Mary.
Yes, Mr. Burwa.
Well, the PM report not received, my lord, in this case, my lord. And regarding, my lord, other materials, my lord, there are witnesses, my lord, who was implicated, my lord, that before she committed suicide, my lord, the accused person, he came, my lord, and they had some quarrel, my lord, quarrel with each other, my lord, and after some time, my lord, she committed suicide, my lord. So abatement part, my lord, cannot be ruled out, my lord, but without the postmortem report, my lord.
Today, as on today, lordship, 75 days. And merely, lordship, that broken relationship is there, that may not amount to, lordship, that 107 or 108, lordship. And
But
78
Mr.
days.
A. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Burwa, learned APP for the state, and also so and so for the informant, for the informant. You have any submissions to be?
There is an allegation of blackmailing with regards to the forceful marriage which the petitioner wants to commit to the girl. When she denied and the family denied, there was repeated attempts of blackmailing which led her to take this step.
Is there any material of blackmailing?
Lordship, we have submitted the FIR that we are ready to submit the cell phone which is recovered from her house. That also may be sent for FSL, and the police in the investigation will come up with.
No, I mean, what was the material, I mean, available on record now?
WhatsApp chat was found in the phone of the victim girl.
Is there anything on the
Yes,
case
it is
there?
there.
Huh?
That is a mobile has been seized, my lord.
No, is there anything?
My lord, mobile has been seized, my lord, and my lord, the witnesses has implicated, my lord, that there were some WhatsApp calls.
Maybe they are, WhatsApp, what is the content of the WhatsApp? Anything?
That is not there, my lord. The contents of the WhatsApp are not there.
So and so. This is an application number, you written. Application number, so and so. An FIR was lodged on 1/12/2025, intimating that on 17/11/2025, the minor daughter of the informant was found hanged herself with a ceiling fan. Thereafter, on 20/11/2025, a mobile phone was found in the bag of the deceased daughter, which mobile phone not mobile phone, you have a mobile number, a mobile number found in his deceased daughter's bag, and it was found that number belongs to the accused applicant. It was alleged that there was some quarrel took place between the deceased girl and the accused person before her suicide. It was doubted that it was suspected that the accused applicant and the deceased girl must have had some love relationship, and due to the quarrel with the accused applicant, the girl committed suicide. suicide. Suicide full stop. On receipt of the FIR, the police police registered Sri Bhumi PS case number 498/2025 under section 107 of BNS. The learned counsel appearing for the accused applicant submits that no material as such has been found against the accused applicant showing his involvement in any involvement in abatement of suicide of the accused applicant. He submits that being in a love relationship and break off of the same cannot be termed as termed as an act of abatement which induced the victim girl to commit suicide. He submits that the accused applicant is already behind the bars for 75 days. 75 days, and therefore he submits that the accused applicant will be granted bail at this stage. Granted bail at this, granted bail as charge sheet not filed, huh?
Actually, no, investigation is pending.
Hmm?
Investigation is pending.
So granted bail at this stage, full stop. He submits that he will fully cooperate with the investigation in the instant matter. Mr. R.J. Borua, learned APB, on the other hand, submits that investigation is still going on and postmortem report is not there.
Not received, my lord.
Postmortem report is also not received as yet. Therefore, at this stage, the bail should not be granted to the accused applicant, Mr. A. Laskar. Mr. A. Laskar, the counsel appearing for the respondent number 2 submits that there are various materials of blackmailing the victim girl by the accused applicant are available, which will be coming out during the investigation. Therefore, at this stage, the accused applicant should not be granted bail. This court has gone through the case diary that has been produced before this court, as well as heard the submissions made by the counsel appearing for the parties. Will stop taking into account that the long detention of the accused applicant of 75 days and having prima facie not having prima facie satisfied that at this stage the accused applicant should be granted bail. It is directed that the accused applicant should be released immediately on bail, on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of
Chief Judicial Magistrate Sri Bhumi.
Chief Judicial Magistrate Sri Bhumi, subject to the following conditions, that the accused applicant shall cooperate with the investigation of the case and make himself available as and when called for by the investigating officer. Number 2, you write the accused applicant shall not try to get in touch with any of the members of the victim's family. Victim's family, full stop. The accused applicant shall not try to influence the witness. You write that, huh? In view of the aforesaid directions, the instant bail application is disposed of as allowed.
May I please the lordship, my lord? This is a regular bail application, my lord. And my lord will kindly go to the page number 10, my lord, FIR, my lord, that is. The very beginning of the, my lord, story, my lord, it has been started with false stories, my lord. He said that the informant's son, my lord, Ashatul Islam, along with his wife, went to his father-in-law's house, my lord. Whereas the one lady has made a declaration she is in separation from this Ashatul, my lord, for last more than 1 year, my lord. Approximately 1 year, she has been staying at her parental home, my lord.
Read the FIR,
Yes, my lord. Humble submission is that on last 21/12/2025 at about 6 p.m., my son, namely Ashatul Islam, along with his wife, went to his father-in-law's house at number 2 Kandoli Mari. At night, at about 11 p.m., with pre-planning of accused number 1 and with the leadership of accused number one and two, one group of gunda led by accused number 6 and the aforesaid persons came with dao and lathi. My son's hand and feet were tied up with piece of string, and he was dragged away from his father-in-law's house and taken to field at number 2 Kandhulimari after crossing the river and tied up in a tree by applying Talibani method. He was stabbed with dao, beaten up with lathi, my son, and while punishing him in different ways. The accused persons tried to kill my son, and while punishing him in different ways, the locals heard hue and cry, and the informant at night about 1 p.m. informed Dhing police, and Dhing police, after reaching the in place of
Charge sheet not filed, no?
Madam, charge sheet not filed, madam, investigation is completed, madam. So
Absolutely simple.
investigation is yet to complete, my lord, because, my lord, injury report is not received, my lord. Otherwise, my lord, victim, my lord, he has implicated, my lord, and there are also, my lord, other witnesses, they have also implicated.
What is your case?
My lord, my case is that, my lord, I'll take your lordship to straightway to.
No, you tell me what is your case?
My case is that, my lord, this lady, my lord, about whom, my lord, it has been said that this lady has been accompanied with Ashadul, my lord. She is my younger sister, my lord. She stays at my home, and that is her parental.
Who stays at your home?
This lady, that will be very clear.
Lady means you went to
His wife, my lord, wife.
His wife, Ashadul's wife.
your wife. Why are you saying about lady? I mean, you address your wife as lady?
Not my wife, my lord.
No, no, wife of the, my lord.
Wife
victim.
is the, my lord, wife of the
Correct,
victim, my lord.
victim's wife.
Yes.
Accused, my lord.
No, no,
sister,
no.
my lord.
Yes, this
She is the
lady, this
sister of
lady means like
victim.
victim and wife.
Yes.
Victim and wife went to in-laws place.
That
And
is absolutely-
in-laws place in a pre-planned manner, they tried to
That
kill
is
him.
the allegation, and
They,
that will be very clear.
tried to kill him, and he was found in a different place, tied up with tied up hands
Yes,
and this
That
thing.
is as per allegation.
So what is your story?
Yes, my story is that the original fact is that this Ashadul's wife, who is the younger sister of the accused.
You tell me one thing, how the body of the victim was found in a different place tied up. Who has tied up?
It is the villagers along with the VDP secretary. I mean, when he tried to get inside of our home, after getting prior information, this man always, I mean, try to attempt to get inside and to meet his wife even after separation. This Ashadul.
But they went together.
Therefore, I am referring to Annexure 3 just at page 17.
But they went
This will be
together.
very clear.
Huh?
Right. Page 17, the last page of the petition, my lord.
Page 17.
Yes.
What is this declaration?
This is a declaration made by the Ashadul's wife, and who happens to be the younger sister of the accused. And she has said that her marriage was solemnized with Ashadul just 2 years back, and she is in separation for last 1 year. Therefore, the question of accompanying her along with this victim person Ashadul doesn't arise at all. So
Who is Asima Khatun? Asima Khatun is?
Asmina Khatun is the younger sister of the accused number 1 and wife of Ashadul.
That she will write many affidavits.
No, that is before the executive magistrate.
That will be that a lot of affidavits. I mean, we have seen.
I understand, but even this
No,
there
at
should be
this,
inquiry.
at this stage,
The
no
injury
bail.
reports that
At
will
this-
also say
At this stage, no bail.
Injury
No
report
bail.
the injury reports, if it is
Injury
available.
report not received, my lord.
Then
No, no,
another day we can fix,
allegations are serious. No bail at this stage.
My lord, what I'm trying to submit, my lord, before your lordship, my lord.
You want to wait for the report?
Yes, that is what my lord, I'm trying to submit.
Okay. Heard Mrs. J. Hamad, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Borwa, learned APP for the state. Mr. And so for the informant. What are the things needs to be received? Injury report
Injury
and
report, my lord, of the
medical
victim.
report.
Medical report, my lord.
How many days it is? So many days.
Today,
60
60
days,
my lord.
60 days.
Except, my lord, me, my lord.
60.
Yes. My lord,
60
there are
days.
Fix a short date, my lord, next
60 days.
next week, my lord.
Injury report of the victim is yet to be received. Let the matter be fixed on.
My lord, 27, my lord.
This one.
Let the matter be fixed on 5th.
May I submit one line, my lord,
Fifth,
before your
fifth.
lordship, my lord? The specific allegations are there against 3 accused persons, my lord. And there are altogether 8 persons, my lord. Only I have been booked, my lord. And except me, my lord, none of the persons have been taken into custody.
You are the
Because, my
person
lord,
who
this Ashatul is my brother-in-law, my lord. And he illegally tried to, my lord, get inside of my home, my lord.
Okay,
Even after separation.
that will be considered when on the next date.
Yes, my lord. Deeply.
Not received, my lord.
My lord, I am behind
Both sides are represented. Case there is yet to be received. Let the matter be listed in the.
6 stream, 6
on
stream.
sixth. Allegations are serious, case diary has to be there.
Ladies, my lord.
Ladies also.
6-3. Do good. My lord, let it be 2nd of March.
Second or third?
The third is a holiday, my lord. Second.
Second.
My lord, 24 of the case diary not received, my lord.
51 days, my lord, mandatory period 60 days. You will kindly come to page 24, my lord. The 36 notice. Last time also you've seen 34, 36, no, page 24, my lord.
What?
Page 24, my lord.
What is that?
That, my lord, 36, section 36 notice, my lord. Where, my lord, where is a signation of at least one witness of the funeral should be first as a witness, my lord. Interested by at least one member, one witness.
We'll verify from the case diary, my lord.
That has to be verified from the case diary.
Yes, my lord.
There is no signature of that witness.
And it seems there is a signature.
Normally, family member, one Dizumoni Begum is given. There's my projected as my family member. He is neither my family member nor having a distant relation.
But it can be a respectable person of that.
Yeah,
Locality also.
not a member of that particular area.
Let the case diary, let the case diary
Let
come.
us see, let the case diary come.
51
I mean, 51 days, mister.
So 27, my lord. Next week.
Okay, next week,
27.
case diary yet to be received, let the matter be fixed on, to 27.
27 too.
Wow.
41. Oh, come on, 41. Come on.
Have you received?
Well, scan copy call from.
Huh?
Scan copy call from.
Okay.
Scan copy received. Scan copy of TCR is received as reflected in the course list. So the petitioner is behind bar for 256 days as of today.
But trial not yet started.
Hmm?
Charge has been framed.
Charge only frame, my lord.
On 11/2/2026.
Only charge frame, my lord.
But there are problems with the service of notices.
Yes, my lord. That is, this notice under section 48 is not given. It is not given to the relatives.
See,
And
Mr.
also, last memo is not
I mean, 47, 48 are not complied with.
36 also, my lord.
36 also. 3 mandatory notices.
36 to some extent, but 47, yes, my lord. For 48.
48, my lord. 47, it appears all right.
47, yes, 47 is given.
47
Yes.
is there, my lord.
48 is not
48
there.
and 36.
And 36 also, there is no signature.
Yes.
No signature.
I mean, on this ground, the court is allowing.
But
Yes, your lordships have allowed.
we are also, my lord, helpless. Regarding 36, my lord.
36, I mean, if you don't comply with, then how will we? So records of 37 has to be dispensed with.
6 kg yaba tablet, my lord.
Hmm?
6 kg around the yaba tablet.
Yes, the amount is large. My lord. Yes.
6 kg of heroin, huh?
Yaba tablet.
Oh, yaba.
And 8,90,000 rupees.
The money is recovered from other accused.
Other.
From another accused. Then one of the accused is given bail, my lord, by this honorable court.
For non-compliance.
The accused from whom the money was recovered. Afjal, some Afjal.
He was released.
He was released.
Order is there.
Yes, my lord. I have a copy of the order.
Pass, I don't have time.
My lord. Itu dia naik satu.
Mr. Potter, sir, we don't have any other.
48, your lordships have allowed many bails.
Heard Mr.
All Oscar.
Huh?
All Oscar.
Laskar, the land council. For the petition case applicant, also have Mr. K.K. Parasar and the PP. Hearing concluded. It has been reserved, order reserved. Right.
May it please your lordship. My lord, I was arrested on 01/11 for last 112 days in custody. Date me, sir.
01.
They took.
Hmm?
01/11/2025. Today is 112 days in custody. My lord, initially, the allegation your lordship will find in the FIR, I have given that translated in 2023. The vernacular is also easy to read, it's at page 24. This was lost by the mother. Mother has now been examined as a PW.
Mother two, PW.
Mother is PW two. And the victim is PW one. Now your lordship will kindly see the statement of the victim PW one. At page, the deposition of the witness is also typed. Your lordship may look into the original.
Original I have phlegma, my lord, in the.
Original, your lordship will find.
The deposition is already there in English.
Yes, yes. English also is translated. Your lordship will see page 39. At that time, apart from me, your lordship got page 39.
I got it.
Then your lordship will see at page 40 also your lordship. FIR lost 3 days after the incident.
Up to 6 PW, my lord, already examined, my lord.
Hmm?
Up to 6 PW already examined. Victim examined, mother examined, neighbor also examined.
How many were there in the charge sheet?
Till
6.
6 were there and 2 examined.
Only now IO has to be examined.
IO
And
has
if your lordship looks into the deposition, they have tried to improve the statement after 3 days, and they had initially complained to the headmaster, saying that this sir, while
Total-
returning the script, had only touched my hand,
Total 9, total 9 in the source.
So allegation is basically what?
touching the hand.
Kiss-
Ultimately, that has come.
Touching and kiss, my lord.
Heard Mr. BD Kumar, senior counsel. Yes, yes. Yes, yes.
Allegation is not only touching the hand, lordship. There is other allegation, which the accused person pulled her and kissed in her cheeks. Now, lordship, total 9 witnesses are there, and 6 has been examined, 3 is remaining. And lordship, kindly peruse the last bail order of rejection order of trial court, lordship,
Where? Page?
page 78.
Yes.
Now, lordship, in this order, learned
Hmm.
trial court written in paragraph, the accused is a teacher at the school where the victim is studying, and now matriculation examination is going on. And this examination schedule has been annexed through an additional affidavit by the petitioner himself. Now, the victim is a metric candidate, and the metric examination will start in a few days. On the day of evidence, the informant had expressed her concern about the study of the victim, as she has been mentally disturbed since the incident occurred.
You got it,
Now,
got it.
this person is
Got
the
it.
teacher.
See, madam, I mean, he's
placed under
already
suspension.
112 days he's inside.
Yes, lordship.
First, secondly, I mean, yes, there was some indecent allegations. Allegation of some indecent activities. That is true. Now prime witnesses have already been examined. So keeping him inside the jail, whether any purpose will be served.
Lordship, in this point, I want to submit, Lordship, this is a POCSO Act, not the IPC offenses, wherein we deal with 90 days or 180 days.
POCSO, which POCSO?
POCSO
Which section?
Section 10 of the POCSO Act.
So
where
section
maximum
10,
punishment is 5 years, not
Correct.
less than 5 years.
correct, POCSO 10 bars this thing.
Yes,
I-
29, there is presumption
Hmm.
as per 29 of the POCSO Act. And regarding this, the previousness of this
29
offense,
says what?
presumption as to the
This presumption is there, but we have rebutted this presumption by cross-examination. Ultimately, if I take your lordships to the cross-examination, it is only the touching of the hand. The other things are all improvement that I have put the contradiction, everything. First time in the court, they have tried to improve some of the things. It is only touching of the hand, that to the headmaster. When it first complaint was filed to the headmaster, he said that she had only complained that they, while returning the script of that drama, the sir has touched the hand. Her colleague has, her friend has also said that she has only complained to the headmaster
Lordship,
that I had
paragraph-
touched the hand.
Lordship, section 9, that is the aggravated sexual assault. Section 10 is the punishment for aggravated sexual assault. And Lordship, this person is the teacher and the victim is the student under 16 years old. So matriculation is going on as per their schedule submitted before this honorable court till 27. So at this stage, this person released, and the mental stress of the victim, the child, under POCSO Act, that will affect the education as well as other factors. Lordship, I'm submitting as Lordship, not for the victim or this, but on the point of law, and I want to submit 2 judgments of the Honorable Apex Court. Recent judgment wherein these factors has to be looked into at the time of granting bail to the accused under POCSO.
My lord, we have annexed the matriculation certificate to show that the matric will be over on.
Give me the
20
case law.
Matric will be over on 27, and he has already been suspended from his job. And your lordship can observe that for the next 7 days, he will not go to the school till the exam is over, and he can't go also. So, and I can show it from
The incident happened when?
Well, in October 29.
29,
29th of October.
started now.
Metric started now. And my lord, she has said, I don't even know whether sir is inside the jail or outside doing cross-examination. And she has said that I told the headmaster
Which
only.
paragraph, madam? Which paragraph of this case?
Lordship, X versus the state of UP,
Yes.
from paragraph 13.
You show me one, that important paragraph.
Paragraph 13, my lordship. 497 page.
Citation to person. Citation to person.
Yes, which are about paragraph 13 and
13, 14, 15, 16, 17, 18. And this POCSO Act is beneficial legislation to protect the child under 16 years. And in the trial court judgment also it has been reflected that if he was released, then victim will be suffered in giving examination as well as he is influential because he is the teacher of that school.
no, at this stage, how he'll influence? She has already given her, statements.
No, Lordship.
The victim and the informant, they have already been examined. Now, how, they will be influenced by the teacher.
Lordship, influencing the witnesses, I'm not saying. The matriculation examination is going on as per the document submitted by the.
No, so matriculation, how, what will happen to her
100
matric?
Page 107.
Lord, all the witnesses have been examined. This Caesar witness is regard to medical. So medical was nothing. So they public prosecutor said on the next date we'll call the I. And your lordship will see the teacher who has given the evidence at PW 4 at page 72. Page 72, your lordship will see. Every case law will have to apply in the facts of a particular case. Your lordship will kindly see page 72. Page 72, your lordship will see the second paragraph, the last line. We remain in the library for about 10 minutes. This was where the place of occurrence.
Where?
Page 72.
72, which paragraph?
Paragraph number 2. I did not give any statement before a magistrate. The police did not seize my mobile phone. Today in court, I have not seen the script that was given to the victim and Bhogirot to read. Bhogirot is also one of the witnesses. I'll take to his. Nor have I seen the mobile phone recording. We remain in the library for about 10 minutes. At the time of the incident, I was the president of the Women Harassment Committee of the school. I did not leave the victim alone with the accused in the library even for 1 minute. I was present in the library during the entire period of dialogue, recitation, and recording. The accused did not commit any sexual assault upon the victim in the library. I did not see whether the accused's hand touched the victim's hand when she returned to the script. No incident as alleged in this case took place. Now your lordship will see the statement of Bhogirot.
Lordship, this is a hostile witness.
Please,
This has been declared as hostile.
Yes,
Because
hostile
he
to
is
that.
one of the teacher who is present
No, your lordship
when
will see the
these
statement.
two students were called for.
Okay,
at the
Bhagirath,
library.
Yes, madam. Please, madam, let me submit. You have made your submission with utmost respect. Amicus curiae.
Bhagirath.
Yes, Bhagirath also I will show you. Bhagirath is PW3, page 62. Page 63, your lordship will see Bhagirath's examination in chief. Second paragraph. Page 63, second paragraph. In my presence, he was there when they skipped because
63 second paragraph.
second paragraph. On the next day, while I was in the classroom, the victim asked me to accompany her to the head sir room. I went to the head sir's room along with the victim. In my presence, the victim told the head sir that after my dialogue was completed the previous day, the accused allowed me to leave and asked her to recite her dialogue. And after she finished reciting her dialogue, when she went to return the paper, the accused caught hold of her hand. That is the initial reaction after 24 hours. Then your lordship will see the evidence of the headmaster who had taken the complaint. He is PW 5, page 92.
Page 92.
Yeah, additional affidavit.
Yes.
Page 92 in examination. This is the prosecution witness, my lord. Page 92, last line. On 30/10/2025 at about 3 p.m., while I was at school, the victim came to me and said that on 29/10/2025, after recording the video for Bir Gatha, the accused held her hand. Then your lordship will see page 94. She is a football player, so she brought some boys to the school. That page 94, your lordship will see the second paragraph. It is true that the boys did not mention in the complaint letter that the accused sexually harassed the victim or held her hand. They allege that they have seen the accused performing immoral activities in the school. They did not mention any kind of specific incident and requested for the suspension of the accused from the school. It is true that before this incident, no kind of immoral activity of the accused had come to my notice. Then your lordship will see page 95. Page 95, second paragraph. There are no stairs to go to the classroom and other rooms of the upper floor of the school, although there is a ramp to go up. On the first floor, there is a classroom near the library. On the day of the incident, the school was open and students were present. Then your lordship will see the just few lines below, who is PW4, Iruni Kosari. Iruni Kosari informed that she was present during the recording and that she came down from above together with the accused. I directed the Women's Protection Committee of her school to investigate regarding the incident with the victim. According to the report the said committee gave me, they found no evidence of any kind of sexual harassment incident.
But this committee's lady is the other one, no, who got hostile.
She was removed from the committee when she was part of one of the witness. So she was removed from the committee and a separate committee did the investigation. That your lordship will find in the evidence of PW, the lady PW4 who has said that she was removed from the committee. Now your lordship will see why the mother has lost the FIR. That your lordship will find the evidence of the mother. Just a moment. PW, page 50.
Yes.
Now your lordship will see at page 52. Page 52, your lordship will see last third paragraph. I did not witness the incident with my own eyes as stated by the victim. I lost the FIR and gave my testimony today. Then your lordship will turn at page 53. Page 53. On the day the victim informed the head sir about the incident after she returned home and I asked her, she told me that she had told the head sir that the accused had held her hand, but she did not tell the head sir about the accused holding her waist and kissing her as he felt hesitant to say so. Then your lordship will see the last paragraph again. Why this FIR was lost, man. On the night of the day of the FIR was lost, Kiranjit Deuri, Nityananda Buragohai, Bichitra Bhuya, Bhunja, Bipul Kosari and my brother-in-law came to our house and informed us that although they had submitted a written complaint to the school authorities, the authorities had said that no action would be taken. They also told us that if we did not file a case regarding the incident, there was a possibility that the school authority or the accused might file a defamation case against them. Therefore, on the night of the third day from the day of the incident, we went to the police station and lost the FIR. Because FIR was lost 3 days after the incident. Immediately they started.
Yes, madam, what do you have to say on
Lordship,
this?
against this submission, Lordship, kindly 5 minutes, Lordship.
No,
the
I mean,
lar-
yeah, you just give me a specific answer about this statement.
Yes, Lordship. One Bhagirath statement has been read
No,
over.
forget about this. I'm asking page 53. 53, this last paragraph, what he has already read out. Yeah, do you have any answer to this? You give me a convincing answer.
50. They also told us that if we did not file a case regarding the incident, there was a possibility that the school authorities or the accused might file a defamation case against them. This statement will not, Lordship, vitiate the offense committed by this accused person. Lordship.
Of what offense?
now
No, what
at least-
offense he has stated? She has stated only the, I mean, allegation of holding the hand, right?
No, Lordship, evidence has to be read as a whole, not.
No, I
not
understand, madam, I understand.
True.
I understand, madam.
She has stated.
Is it a kind of, an allegation has been already made, okay? And she is not a very small child also.
Yes.
She is a matriculate student.
Football
Yes.
player.
Correct.
Under 16.
Under 16, under 16, how do you say under 16?
Lordship,
Is there any material?
Yes,
Where?
under 16. Under 16.
Under 16?
Sir, in her deposition, maybe. Deposition is there, PW1 is the victim.
Yes, let's see, where is that?
16 years PW1, page 44.
She's not under 16.
About 16 is about 16, it has been written as.
But anyways,
Page 38.
anyways.
And Lordship, the Bhagirath statement, the learned senior counsel has been stated that one paragraph has been read over, that second paragraph, page 63, kindly Lordship, page 63. Learned counsel has read over from second paragraph on the next day. I am reading from the first paragraph. After reaching the library, I first recited my dialogue. As I had not fully memorized the dialogue, the accused held the dialogue paper in one hand in such a way that I could see it, and with the other hand recorded the video using his mobile phone. After I finished reciting my dialogue, the accused told me that it was good, and I left from there. At the time of my leaving, only the accused and the victim were present in that library. And this, some women commission person, she was one of the person who, along with the accused person, called this student, Bhagirath, and the victim. Bhagirath, after his work done, he left, and this lady left. But this is the afterthought. It has been a defense story put before this honorable court that she is with the accused at that time. That is wrong, because Bhagirath said he left, only accused and the victim was at that library room.
Your Lordship will
And
kindly
evidence is
turn to
that-
page 64. What did the
Sir,
Bhagirath say to police? My lord, we have put it in cross, page 64. Page 64, your Lordship will read the second paragraph.
Lordship,
It is
I
a
am
fact, it
submitting-
is a fact I stated before the police that when Niharika went to return the papers, sir caught hold of her hand. There is no kissing, nothing, my lord. This, and your Lordship will see, we have put it also that it is a fact that I did not state before the police that Ironi Kosari madam called me and the victim from the classroom to the staff room and gave me the dialogue of Piolificon and the victim the dialogue. He has all denied it, my lord. Simply, and this house of the victim, we have brought it, it is just next to the school. They did not complain to the mother, did not complain to the school authorities. The father did not complain. We have also cross-examined the father. My lord, your Lordship will see the cross-examination of the father also.
And Lordship, they have to.
My lord, this is not a
during-
case, my lord, where further custodial
Whether they are
detention is required of the accused for the purpose of the trial of the case. Because all the witnesses have been examined. Now the medical has no meaning. That's why this medical witness will not be called. That's why I said that all the witnesses have been 110 days in custody, already suspended, and exam will be over on 27. Your Lordship can protect the interests of the victim.
Lordship, petitioner himself said.
Yes,
on
yes, I said,
27
I'm
was-
fair. I can suppress those medical. I'm not an officer of the court to suppress anything from the court.
And my
You are an amicus
Lordship,
curiae, you are not
amicus curiae means what? I have to stop.
my bill.
Bill, I am not saying bill. I have to submit before this court. Loyal.
Yes, please.
Lordship, my submission is, this is a, number one, this is a POCSO case. Number two, petitioner himself said that matriculation is going on till 27 February. Number three, trial court judge rejected the bail prayer, considering the fact that if this person released, then the matriculation and under stress child will be hampered. So that's why the bail has been rejected by the trial court. And evidence of three witnesses is left.
No, those are.
8 witnesses has been examined and three of whom were the teacher's colleague of the accused person. So they are putting such a story to prove that this accused person is with some Eureka. Eureka was not with that, and this is a defense story, and they have to prove at the time of defense, not at the bail application, Lordship.
No, no,
And-
Eureka is the prosecution witness, it's not defense.
And
witness.
3 witnesses left.
It's your witness, means the public prosecutor's witness, Eureka. So it's.
Maybe that is your suggestion, that is your.
Oh, no, I'm not
you have to-
sure. She has admitted.
And Lordship, I leave it to the Honorable Court. My submission is regarding to assist the court regarding the POCSO Act, regarding the provision, regarding the child, how to be treat with the child after commission of such type of offense, special legislation, beneficial legislation, recent Supreme Court judgment I have submitted before this court, and there are.
I mean, yeah, in
Make
those
file.
cases, you give the paragraphs.
Another judgment is
The
there,
first case, you have given 13,
13 to 18,
13 to 18,
and the next one is 11, 14, 16, 18.
14.
11, 14, 16, and 18. Sumoto writ petition. And in this writ petition,
11,
some 11, 14,
14,
16, and 18.
16 and 18.
18.
Okay, okay.
And in this writ petition, some committee has been formed regarding the bail order passed mechanically in POCSO Act, Lordship. These are discussed here.
Okay, thank you.
recent
Thank you for your assistance. And like, we'll do one thing. We'll pass the order. I mean, I heard Mr. B.D. Kumar, a learned senior counsel, assisted by so-and-so. Also heard Mr. K.K. Parasar, APP, as well as M.S. N. Chaudhary, the learned amicus curiae, on behalf of the informant. Hearing concluded, order reserved.
Obliged.
Please, Lordship. Kindly adjourn for the day, madam, on behalf of SC, because we have some personal.
On the prayer of the learned council, the matter is adjourned for the day.
Yes.
28.
May I please, Lord? My lord, after filing of this petition, my lord, charge sheet was submitted, my lord, and it
You go and appear. No, charge sheet has been submitted.
submitted, my lord.
Yes. Then?
My lord, LCR was called for, my lord. LCR was, scan copy of LCR, my lord.
It has come.
LCR has come regarding service. Oh, service complete.
Service not completed.
Service complete.
Huh?
Service completed, my lord. Amicus may be appointed.
We will wait for another date. Both parties are represented.
Amicus may be appointed. Next.
Service on respondent number 2 is completed. However, none appeared for the respondent number 2. Mr. A. Fukan is, give the amicus list. MS Adrita Bhuya is appointed as amicus to assist this court on behalf of respondent number 2. The learned counsel for the accused applicant shall submit a copy, shall furnish a copy of the application to the amicus curiae within 2 days. Let the matter be listed let the matter be listed on 6th, on 6th, we have fixed so many matters. I think let the matter be fixed on 10th of March. Come.
32. 31. 31, I think. 31.
32.
You know, so the senior counsel is on her, he's on his way.
Pass off for them.
Your FIR, Lordship will find.
33.
33 I am appearing. Page 10 is the FIR, Lordship. Here, no allegation against the present petitioner, Lordship, except the fact that the vehicle from which, Lordship, aircraft were recovered, he is the registered owner, Lordship. And he has given the vehicle on rent, Lordship. That rent agreement I have enclosed at page 60 to the person who was named in the FIR as driver, Lordship. Page 12, your Lordship will find the driver and co-driver's name. And that agreement, your Lordship will find page 16. The admitted fact that I am the registered owner of the vehicle, Lordship, but it was driven by that driver and that handyman, Lordship.
The the material belongs to whom?
They can say, Lordship, because
Huh?
I am getting, Lordship, 80,000 per month from that driver, Lordship, that after.
So you are allowing it to, do some illegal activities.
No, that part is looked after by the driver himself, Lordship. That the agreement also it is mentioned, Lordship.
My lord, 4,385 kg of Areca nuts were found, my lord, in 1929 gunny bags in a secret chamber, the backside of the truck vehicle, my lord. Now, my lord, as per the statement of the driver was arrested, my lord. He stated that, my lord, before I starting this driving this vehicle, my lord, there was secret chamber. So he is the, my lord, owner. So he, matlab,
The secret chamber is where?
matlab, backside of the vehicle, matlab. And he is the owner of the vehicle, so it is, matlab, otherwise to facilitate to such type of activities, perhaps, matlab, it has been made, matlab. Vehicle was taken to, matlab, some, carrying some potato to Manipur. Subsequently, when they come back, matlab, this 129 bags of Burmese, suspected Burmese supari, matlab, Areca nuts were seized. And no documents, nothing were. Driver was arrested, matlab, earlier. Now he is the, matlab, owner.
Driver and handyman both arrested.
পিছফালৰ ক্ৰিয়া দুটা চেম্বাৰ বনোৱা আছিল।
Is there anything in the case diary?
Well, as per the statement of the driver and the handyman, there was secret chamber in the vehicle, and while returning from Manipur, they this.
Can you just brush aside your liabilities when your vehicle you have given on a rent and wherein a secret chamber has been made without, I mean, you will definitely say without your knowledge, whether you can do that. I mean, don't you keep your vehicle in your vigilance? I mean, you don't keep it when you give a vehicle on rent and your vehicle has been, has been used for illegal activities.
No, he was carrying those articles when he was returning from Manipur.
No, whatever, whether it's a Manipur or whether it's Nagaland, doesn't matter.
No, the present petitioner, Lordship, he resides at, Lordship, in Assam, Lordship. He normally
Where does he reside? Where does he reside?
that is, he is from Dhula, Dorong, Lordship. And he do not travel along with the vehicle, Lordship.
No, no, it's obviously,
Right.
obviously the owner doesn't have.
ড্ৰাইভাৰ মানে মই যেতিয়া গাড়ীখন প্ৰথম চলাব লৈছিলো তাৰ আগৰ পৰাই চেম্বাৰ বনোৱা আছিল
Mm.
তো মানে this type of activity is going on.
Personal interaction at this stage, Lordship.
No, 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 I mean.
Because they also, Lordship, sought time for CDR, Lordship, to ascertain
No, no,
whether he was in personal
AB will not be given. No, sorry. Heard Mr. A. Ahmed, learned counsel appearing for the accused applicant, also heard Mr. R.J. Burwa, learned APP for the state. This is an application under so-and-so. The allegation as narrated in the FIR dated 15/11/2025 is that the vehicle, the six-wheeler truck owned by the accused applicant was used for smuggling, 4385 cases of areca nuts packaged in 129 bags. Full stop. The police recovered and seized those areca nuts along with the vehicle. Full stop. That next para. The police arrested both the driver as well as the handyman of the vehicle. And on the implication of the driver of the vehicle, stating that the vehicle is owned by the accused applicant. The accused applicant has approached this court by filing this bail application. The learned counsel appearing for the accused applicant submits that the accused applicant has rented out the vehicle with a proper rent agreement which was signed prior to the incident, and therefore he is not aware of any illegal activities committed by the accused by the handyman and the driver of the vehicle. Full stop. The CD in the instant case has been produced before this court and which has been perused by this court. The learned Mr. K.K. Parasar, the learned APP has submitted that there is a specific statement made by the driver of the vehicle that the vehicle contained a secret chamber and which is known to the accused applicant. Full stop. On perusal of the case diary, as well as after hearing the counsel appearing for the respective parties, this court is not inclined to grant anticipatory bail to the accused applicant at this stage and hence the same is rejected at this stage.
All right. 32. Let us see the last order that has been passed by this court.
Yes, my lord.
See the last order that has been passed on 17th of February 2026. Please see that order, my lord.
17th.
17th of
Yes,
February
yes, yes.
2026. So and so appearance state, so and so. Kindly see the 3 lines.
Yes. Well, it isn't filed.
My lord, no, my lord, I have my lord, not my lord, my office staff has telephonically talked with the OC. And they have instructed that my lord charge sheet submitted and charge sheet number also given. I telephonically taken from our office. Now my lord, when I inquired my lord that no my lord W2 message was there, whether it is seen or not. So specifically yesterday I have talked with the IO my lord. She stated that some investigation is still required and it is not given. So why some miscommunication is there, maybe my lord. And now
one thing.
today morning,
The charge sheet was not filed.
filed today morning my lord they have.
But what I.
No, how many days have
My
gone?
lord,
No, I say B.
I'll tell one
Oh.
thing. Before that, my lord,
Oh.
if your lordship permits me. On that day, your lordship has seen that my learned friend, they said that the information, the charge sheet has been filed. That was noted. Immediately, I had a doubt. And I told my learned friend, get a certified copy. What is the position whether? And here receive a certified copy and found that only the FIR knows no charge sheet has not been filed.
No, my lord.
So only, no, that's why I know, my lord, why this has been done. There is a pressure in it, that's why. Now today, my lord, what remains in this case, my lord? I don't understand. Kindly see, my lord, this is what we have applied and we found.
No, I mean, he has already stated.
I am saying that one is a very careful when he say the charge sheet has been
My
filed.
lord, telephonically.
No,
what
he, I mean,
I
he
have-
may
I
have
have
got
the court.
some,
He
it happens.
That's what I know, my lord.
No,
I know
anyways,
also.
that episode is gone now.
Yes.
Now charge sheet is not there.
Not there.
So now what is, I mean, is there anything
My lord, yes.
whereby, what was the
But as
allegation?
far as
My lord,
yes.
for kindly see at paragraph, page 13 is the FIR,
Yes.
13. One, just 13. It's a type copy.
Hmm.
This is a English, my lord. There is no absolutely no problem
Mhm.
because 17 is also in English.
Hmm.
It's very too small, that's why I typed out.
Okay.
But kindly see FIR, now on complaint, namely so and so, daughter of so and so, resident of so and so, age 29 years, so and so, causing the repeatedly promised to marry her and portrayed me as a future in father and he proposed her with engagement. Now, I'll just tell you, it's a big one. It is a case where from 2020 they had a relation till the date when they broke up. And it appears from WhatsApp that why they have broke up at one point of time. My father was unwell. 2020, the relation was there. They are all major. One is a doctor and one is a businessman. Now they were together 2021 relation was there. My father was not well. So she accompanied along with my family at Delhi and they stayed together with my family. And ultimately, at one point of time, they said that there was some agreement, promise to marry. This is what has been narrated. And taking advantage of this sexual intercourse has taken place. This is what it has been projected. Now we got my lord, the WhatsApp. Please see WhatsApp message. At page 20, kindly see, my lord. I'll not read those messages.
Yes, yes, yes.
Kindly see the message. Don't want to read this message also. See 21. 21, please see. See, my lord, 21. First, second, see, not tick mark, two double tick mark thereafter. Left side is the informant, my lord. See, please, 22.
Mr. Parasar, with this kind of, messages, with this kind of messages, I don't think this court is going to.
My lord, only one thing is that, my lord, yes, there is promise to marry, and because of that promise, my lord, physical relationship, yes, girl is major, my lord, no doubt, my lord, she is a doctor, and subsequently she became pregnant, and my lord, it was aborted by her, my lord, when she pressurized her to marry, not, I will marry you after 1 year, as per 183 statement. Subsequently, she aborted herself, my lord. And now, my lord, regarding the promise, my lord, one photograph, not the original copy, but one photograph, it is written in the, my lord, stamp paper that I so and so Kaushik Das promised to marry. So, my lord, that promise, my lord, not orally promise, my lord. Also, if the promise is given, my lord, through my lord, signing in the stamp paper, there are witness also there. Now, not in earlier case, IPC it is not there, but as per section 69, kindly
69 BNS.
BNS.
Hmm.
69 BNS. Sexual intercourse by employing deceitful means, etc. Whoever by deceitful means or by making promise to marry.
Okay, when was this agreement?
Agreement, my lord, this on stamp paper, just only.
No, when, what was the date?
Date, it is in the photograph, it is not mentioned, but in her statement, 183 statement, she said that in September 2020.
September
2020.
2020.
20.
I mean,
So
that agreement.
He promised writing, and there are the witness also there promised to me.
They have mentioned, they have filed an objection, which is reflected in page 41. So it's 41 of
And June 2024, she became pregnant and subsequently aborted. June 2024, pregnant. Now, as per the deceitful means as per now 69. So it is now it is extended to 10 years punishment. Earlier in case of IPC, it was not there. Without any making promise to marry to a woman without any intention or fulfilling the same, has sexual intercourse with her, such sexual intercourse not amounting to to the offense of rape shall be punished.
Have you gone through this, have you gone through these WhatsApp messages?
My lord, yes, sir. Yes, yes, my lord.
And you see the language he has used.
That is also-
It is not the boys, I mean,
Yes, my lord.
I mean, I mean, I don't want to read all these things.
No, yes, I have.
You can also go through it. I mean, then can you say, I mean, like, is it, I mean, actually you can say it's a deceitful activity with this kind of, I mean, messages. Both of them are
Well,
educated people.
my lord,
Both of them are measures.
ring ceremony also there, as per my photograph are there.
After this, I mean,
I just don't want to read. Please see page 25. Please see 25 of the AB. See 25. See 25. First, second, third, fourth, fifth, sixth, seventh. See, my lord, this is what. See page 25.
yes, what do you have to say?
Submit.
No, you submit from there, I can hear you.
Yes.
Yeah, tell me.
Lordship, I'm appealing for the informant in this case, Your Lordship.
Yes.
So what has happened is that the petitioner is already on interim, Your Lordship, and my senior Lordship, Mr. A.K. Bhuya, he was waiting all day. He was not feeling well, so he went. My humble prayer, Your Lordship, is that rate be fixed on Monday for.
No, not at all, not at all.
Because the informant will
Not
not
at
be,
all, not
will
at
not
all.
be represented to the best of her ability.
Not at
Her
all.
ability.
You appear on behalf of him.
That's why I'm praying before your itself by folded hands, Your Lordship.
You, Mr. Parasar, you give me the
My lord,
CD.
CD I applied.
You have filed an objection, right? Where is that? One second.
We have received the objection also.
A short break, Lordship.
Oh, no,
Days,
no,
Lordship.
no.
Because he is in interim, Lordship. He will not,
No, after hearing this much, not at all.
My lord, can I just, with your lordship permission,
Yes.
can I show one judgment of the Supreme Court? Is one of the latest judgment of the Supreme Court, my lord. 2026 of Nagaratna, Honorable Justice Nagaratna and Mr. Bhuya, my lord.
Yes, yes, I
Is
have.
one of the latest judgment of the Supreme Court. I think exactly it is what it says. And the entire affair was quashed, my lord. Kindly see.
No, this I am aware of. You just read the relevant
See
paragraph.
25. At this juncture, it is important to place reliance upon observations wherein this court speaking through one of us. So I observe that mere breakup of relationship between a consenting couple cannot result in initiation of criminal proceeding. What was a consensual relationship between the parties at the initial stages cannot given a color of criminality when the said relation does not fructify into a marriage. Furthermore, this court in so and so through one of us observed that this court has on numerous occasions taking note of so and so wherein failed or broken relationship are given the color of criminality. The offense of rape being of the gravest kind must be invoked only in case where there exists genuine sexual violence, coercion or absence of free consent. To convert every sought relationship between offense of rape not only trivializes the seriousness of the offense, but also inflicts upon the accused indelible stigma and grave injustice. Such instances transit the realm of mere personal discord. The misuse of criminal justice machinery in this regard is a matter of profound concern for the judiciary, already facing a heavy load and calls for condemnation. Now, please see 27 now.
Yes, I have gone through this.
27 is last saying it has been quashed.
Yeah, I'm aware of this. Yes. There is no date in this, I mean, that what about what about a note there?
In her 183 statement, my lord, it is mentioned that September 2020.
Now, she has mentioned in the objection also, but how do we find out? How do you find out?
My statement also been recorded.
No, we are not disbelieving this. We are just saying that, is there any date on this? Where?
Backside, my lord, when it is purchased, so see, it is September 2020.
Purchasing will not give you.
In a statement,
I mean, give a document which is, I mean, the document and like this thing which is, can be, I mean, like legally, I mean, a stamp paper of like this can be bought by somebody in the 1950, and like they can sign it and like give it to the court saying that, I mean, we have done it in 1950. Will that?
It is corroborated by the statement, my lord, 183, my lord. It is promissory note, my lord. Nothing else.
May I submit, Lordship? The Honorable Court is not going to give time, Lordship. I'm going to submit, Lordship.
No, but I mean, you have submitted, then.
Lordship, in that document is of 2020, Lordship.
Yes.
And at that time, these situations were not arises. Now 2026, he refused. And the messages which has been submitted by the learned counsel of the petitioner.
Senior counsel, madam.
Learned senior counsel, I'm sorry, Lordship.
You give respect to some people who are senior to you.
Lordship, I have respect towards the.
So when you address a senior counsel, you address a senior counsel as senior counsel, not as a counsel.
Lordship, I'm sorry, Lordship. Now, Lordship, some of the messages they have annexed in the petitioner in page 19.
Page 19?
Page 19 of the bail application, Lordship.
Yes.
And
But
they-
those, I mean, Chaudhary,
Yes, Lordship.
those messages are not readable. Can't be read, I mean.
And Lordship, in this page 19.
Yes.
10 messages.
Yes.
Has been annexed with the.
No, what do you want to prove by this?
I want to say there are communication between both the persons.
Correct.
Under false promise from the inception. And this girl entered into physical relationship with the petitioner with the hope that, and with the promise given by this accused person in the year 2020 that I will going to marry you.
2020
So,
document, 2020 document is there, yes.
yes,
After that, like which message you are referring to?
page 19.
Page 19, yes.
28 February, no. The main petition. Page 19 of the main bail application, Lordship, the learned senior counsel has annexed. Date 28 February 2025, some of the messages they have annexed.
Okay.
And we have taken out all the messages. some of messages we have annexed with the affidavit in opposition, which we have replied, and all other, there are thousands of messages on 28 February 2025.
See, I mean, Ms. Chaudhary, you are also aware when a relationship goes on, this kind of messaging happens, right?
Yes, Lordship.
This kind of messaging happens. The emotions go here and there. I mean, you are emotionally, sometimes you are down, emotionally, sometimes you are, you are in a different mood. So you give all these kind of messages in a relationship. Correct. You give a lot of promises also. I'll do this, I'll do that. I mean, it happens that like a person when they are in love, I mean, they give a lot of promises. I mean, those promises are fulfilled or what? Or when they get married?
That's what, Lordship, this provision has
So-
been,
so
this
this kind-
provision has been incorporated in the IPC, Lordship.
I don't know, this provision, then what about this case?
Lordship.
What about the Supreme Court case, the latest case?
The facts of that case
Yes.
and facts of
How
this
it is, and
case-
how it is distinguished, you tell me?
Lordship, this is since 2020, she entered into the house. She obliged all the rituals of his father. She stayed in the in-laws' house. She was introduced as the wife of this person, and all these messages, which attributes the promise that has been committed by this person, Lordship, and under that promise, the physical relationship, the child abortion, all thing has been happened, and Lordship,
And as far as the abortion is concerned, I mean, is there any forceful abortion?
forceful due
huh?
to this, he refused.
The girl is a doctor, right?
Yes, Lordship.
Oh, and was it forceful? I mean, that abortion.
Forceful, not physical forceful, Lordship, because of the mental stress and the refusal to get married. These things attributed to the abortion, and because of this, Lordship, refusal and mental stress, this lady many times tried to commit suicide. And these are the facts we have next with this affidavit, Lordship. And if this false promise has not been committed by this accused person and he got free, then every relationship and every the promise, the every girl will be.
No, first thing is that this document cannot be relied on. No? This document cannot be relied on. You show me something else.
Lordship,
This document cannot be relied on. You show something with something else.
Lordship, this is a bail application, Lordship. This document can be relied on at the trial stage, Lordship.
Don't remind me every time that this is a bail application.
Lordship, prima facie case.
I am taking bail applications only. I'm not taking any other matters. I'm taking bail applications only, and you need not teach me, I mean, how to see a bail application. You need not teach me, okay? Don't remind me every time that is a bail application. I mean, hearing bail application only. You give me a piece of document from somewhere, and you want me to believe this at this stage.
Somewhere, Lordship, this is submitted by the respondent number 2, informant. And it is in the case diary, Lordship. The investigating authority may also seized. And statement has been recorded.
Which document has been seized?
No case diary.
She said this document has been seized. Then where is this document? How come this this original document she has got? You said that this document has been seized. Then how come you got this document?
Lordship, photocopy has been seized, they have stated.
So be careful when you use your words. Yes. Yes, so your case is basically that on the basis of the promise, promise of marriage, you got into a relationship with him and you had some kind of physical relationship with him. And thereafter you got pregnant and you had to abort because of harassment by them,
Yes.
right? Harassment and mental pressure, whatever. Now that since he has refused to marry you, so your case is that only, right?
Yes, Lordship.
And and you have any case laws that you want to submit on your arguments? This Anurag Soni versus
Anurag Soni.
Chhattisgarh, who has filed this? This is yours, Mr. Das?
Yes.
Or yours?
We have given, Lordship. on
You have
behalf
given,
of
okay,
it.
which paragraph?
Lordship, 10.4, page 14, consent.
10.4.
Yes, Lordship, page 14. Okay.
Yes, what is the 10.4?
10.4, consent has been, 10.4, consent has been defined 376 promise to marry, how under misconception of fact, respondent has been entered into this physical relationship. Lordship, this has been entered into, Lordship, and thereafter ultimately conviction under 376 of the appellant has been upheld. Upheld, and it was reduced to 7 years. 10 years is reduced to 7 years.
Madam, one aspect has to be taken into account is that, I mean, certain messages are there,
Yes, Lordship.
okay? So those messages portray that not only for the promise of marriage you entered into a sexual relationship. In fact, you enjoy it. That's why you got into a sexual relationship. That's what the message portrays.
That, Lordship, implies, Lordship, that
That implies
the
a different
petitioner
thing.
is going to
That
marry this lady.
implies a different thing, madam.
And there are other messages, thousands of messages exchanged between
Yes,
both the parties.
at least one message portrays that. That gives a different, different mindset altogether, right?
And Lordship, she was induced to enter into this physical relationship by blackmailing
Blackmailing,
and the
blackmailing
material-
also. What is there any incident of blackmailing also? Just point out where.
blackmailing or assurance given by this petitioner that he is going to marry her. And photographs were also, we have
The
annexed.
blackmailing is different and inducing is different.
Lordship, kindly come to page 37 of our opposition, Lordship, objection.
37?
Page 37.
Yes, what is there?
That the information in April 23, the petitioner's father was diagnosed with so-and-so and was undergoing treatment at Medanta, Delhi. The informant was repeatedly pressured by the petitioner to travel to Delhi to take care of his father at his residence in Delhi from 10/7/23 to 27 7/23. As a result, she also missed her obstetrics posting. In 24, the
Madam,
petitioner
see, you are in a, no, see, you are in a relationship with a boy, and like there were talks of getting married, or talks of marriage, and you are a doctor, so there might be an expectations from the boy's family also that I mean, since she is a doctor, every household thinks that if doctor is there, I mean, it's a helpful. So that may be one of the contents. I mean, one of the what do you say? One of the reasons that they have asked you to come there.
And Lordship,
But how do you, distinguish this case, recent case? Are the facts are different? Anyways, we don't have much time. I mean, we have to conclude.
Lordship, this has been misrepresentation by the petitioner.
What?
Misrepresentation of facts
Which?
regarding marriage.
Misrepresentation of
That
facts
he is
by?
going to marry this girl.
Okay. Okay,
Yes,
he's
and
misrepresenting.
it is since the date of inception, Lordship. This has been going on. And messages, Lordship, there are thousands of messages wherein it appears that this person is going to marry this lady. So
Okay,
under that,
is there anything, Mr. Das, will
Facts.
conclude?
Okay, my lord, there is one judgment. My lord, that is 2000. You know, 2024 judgment.
You have the citation or?
Yes, yes. Citation PO. This is Manu Patra. Party is Lalu Yadav versus respondent. Yeah, I will just get it, my lord. I'll just read one paragraph. Kindly see para 14, my lord. Para 14 of the judgment.
You sure?
I have marked, my lord.
Okay,
Please,
I'll
I'll get it. Para 14. sir.
make
I think this 14 paragraph.
Yes, which lines you want to?
Paragraph 14.
Yes, I have read this.
Paragraph 14. 5 years, my lord. Lordship sees exactly same matches with the case. 5 years.
But their cases from the inception
Yes.
of.
Yes, that's
From
it.
the inception, there was a promise of marriage.
And now that is kindly see, for last 5 years, if that was,
Hmm.
so why there was no FIR which has been lodged, my lord?
Yes.
There was no FIR which has been lodged. So many things has happened, but no FIR were lodged.
Hmm.
No.
If I lost, Lordship, after refusal, Lordship.
Kindly see, my lord, now having
Refusal, it has been lost.
paragraph 14, now having bestowed an excess consideration referred, supra with referring to factual situation obtained in case we are of the considered view, High Court has probably gone wrong in not considering the question whether the allegation in the complaint reveals prima facie that the complaint had given a consent in the consent of sexual relation with the appellant under misconception of facts and released, whether it reveals a case of consent sex. Firstly, it is to be noted that the subject FIR itself would reveal that there occurred a delay of more than 5 years of registering the FIR. Secondly, the very case of the complaint has revealed from the FIR would go to, so they lived for a long period as man and a wife. Here, my lord, they had a relation for, say, for 5 years. And thirdly, facts and circumstances obtained from the subject FIR, other material also on record would reveal absence of prima facie case that the complaint respondent for has given a consent with the appellant under misconception of fact. Any rate, allegation in the FIR would not constitute a prima facie case of false promise to marry from the inception with to a view to establish sexual relationship, and instead they would reveal a prima facie case of long consensual physical relationship during which the complainant addressed the appellant as so and so. Moreover, it is also the case of the complaint reveal a subject FIR, other material record that she went along with the appellant to so and so with the knowledge of her family and stayed with him in hotel during such visit. Subsequent refusal to marry the complaint would not be sufficient in view of the circumstances obtained in the case, and by stretch of imagination to draw existence of prima facie case and consent of so and so with the appellant so as to accuse the appellant guilty of having committed with so and so. So this relationship for the last 5 years, it is a fact that they have gone to Delhi. They stayed together also, my lord. Treatment was also done. My father's treatment also. But unfortunately, he died. Unfortunately, he died. Now, this after so many years, when you is a relations they are broke, now you come and file this FIR saying that there was a sexual intercourse. This is my case, and my lord, 2026 so is kindly see that judgment, my lord. So already, my lord, I'm interim already. My lord, cooperate. My statement is also been recorded, my lord.
Okay, okay, I heard Mr. D. Das, the learned senior counsel, assisted by, what's your name? Mr. A.B. Singh, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Paraswal, learned APP for the state, and MS and Chaudhary for the respond for the informant respondent number 2. Hearing concluded, judgment reserved.
Lordship, I'm sorry if I did something. I'm sorry for any
No,
kind of.
nothing, you need not be. Only thing is that you respect your seniors. That's what I'm saying. Because we
already
have been taught from the very beginning of joining the chamber that respect your seniors. That's all.
I always.
While addressing the. I'll keep this.
My interim bail is already there.
Interim, just person order, interim order, so passed, shall continue till the passing of the order in the instant case.
I'm deeply obliged.
So maybe, I mean, I'll require 1 or 2 days to peruse this and.
I'm sorry to interrupt, my lord. They also, they will first, I think, they also might not, item 54.
I mean, I'm sitting now, 54 is what?
Every minor, every anticipated bail. Okay, what are is there?
54 is bail hearing.
In hearing one. Yes, come, man. I send it.
Okay, give me 54.
Tell me, my lord, the.
Yes,
Petitioner
54.
number 1 is a teacher,
Goodbye,
my lord,
54 this.
of Lapoli Road High School, my lord, and petitioner number 3 is the.
56 and 57.
My lord,
No, the
54.
54.
And petitioner number 3, my lord, he is the retired, my lord, secretary of Water Resource Department. What incident happened, my lord, that they stayed at my lord Krupnagar, but they are having a rented house at Sonapur. And two chiefs entered in the night, my lord, where some
Thieves.
girls were staying, my lord, working in the kidney hospital. Therefore, my lord, mob, my lord, gathered. And one of the injured chief was died, but they were staying, they don't know about the incident. And they are not named in a FIR also. But they are the owner of the house. Incident happened at Sonapur, my lord. And they stay at
Incident
Rupnagar,
happened at
Gauhati.
Sunapur.
Sonapur. They are
And
having
you
a
were,
rented
you were
house.
you were the owner of the house.
Not the house, but we stay in Rupnagar.
You stay in Rupnagar.
Yes, next to the
Incident
house.
happened there.
Yes, incident happened. Two thieves entered the girls' room,
Then?
and some of the girls were staying in, working in kidney hospital.
Hmm.
Then when the girls raised hue and cry,
Mhm.
then my lord mob gathered, including they are having a resort also nearby.
Hmm.
Their employees and other my lord gathered there, and my lord the chief also hit by lathi to the mob my lord, and my lord.
The thief died.
One of the thief not died, he died my lord on the way to GMC.
Okay.
Police came my lord.
Okay.
But
Now,
one of
now,
the thief died.
now,
But
how,
since we are staying
now
in
how
my
you
lord
got,
Rupnagar-
how you got implicated?
No, my lord, FIR we have not been named.
FIR you
but
are not there,
no,
but
no. Only my lord, they are.
Mr. Borua, why they are owners?
My lord, regarding my lord, regarding from the note of the investigating officer, my lord,
Oh.
there is no such sufficient materials found against the petitioner number 1 and 2, my lord.
Huh.
They are the husband and wife, my lord.
Huh.
And petitioner number 2 is he is a son, my lord.
Huh.
And he runs a dhaba, my lord. Whatever, my lord, when they get the information, my lord, regarding one theft, trying to, my
Okay.
lord, commit.
So he also went
He
there.
entered, he also went there, they
Mhm.
brought the thief to the dhaba, my lord, and he was assaulted brutally, my lord, as a result of which he died, my lord.
Mob was
So,
also there.
so other witnesses, my lord, implicated this person also, my lord.
Let him
Along with other,
let him cooperate with the
regarding
investigation.
other accused person, my lord.
There is nothing.
No,
But son also like there was there, I mean, there was a theft and like then the mob gathered, then there was allegation of
gathered,
the.
by
Other
persons
implicated that, my lord, he is also one of the, my lord, person.
Already given,
Assaulted
he's
him.
he'll cooperate, he'll cooperate.
Yes, sir.
Heard
Not
MS
a
and
statement
Sakia, the
taken.
learned counsel appearing for the accused applicants, also heard Mr. R.J. Borua, learned APP for the state. Decision application, you write, the allegation in the FIR dated 28/12/2025, lodged by ASI Samin Nath, is that one person suspected to be a thief was assaulted by a group of people, including the accused applicant number 3.
Number 3, my lord.
Accused applicant number 3.
Not applicant number
that-
2, my lord.
Mm.
Son is 2.
The son is 2, my lord.
Son is 2, okay.
Yes, sir.
Accused applicant number
Yes,
2,
father.
accused applicant number 2. The thief got,
In postmortem report, he
the
yet to
thief,
receive, my lord.
the thief got severely injured, and thereafter while taking to the hospital, he expired.
GMC, yes.
He,
First
he,
they was
he,
taken
he
to
expired
hospital.
in the GMC, full stop.
Thereafter taken to GMC.
Full stop. A coordinate bench of this court, wide order wicket 7/1/2026, has granted, no, just before that you write, the learned, Mr. R.J. Borua, learned APP, has produced the case diary before this court, and he submitted that, that there are allegations of involvement of accused applicant number 2 in tracing the thief, full stop. The case diary in the instant case has been produced before this court, and same is perused, and after hearing the submissions made by the counsel appearing for the parties, it is court is of the considered opinion that the interim protection granted by order dated 7/1/2026 should be made absolute at this stage, as the accused applicants have already appeared before the IO and got their statements recorded, full stop. Accordingly, it is accordingly the interim order dated 7/1/2026 is made absolute in the same terms and conditions as stated therein.
Obliged.
Meeting is. I'll have to rise, I mean, I wanted to sit, but thing is that there is a meeting. I mean, that's no other way. So, I mean, the matters will be split over.
Monday, 56.
So matters will be split over because there is a meeting at 4:45. I'll have to go. I was thinking of sitting, but there is, I mean, the meeting is there. So I'll have to rise.
Monday.
No. I mean, it will be spilled over. It will be spilled over.